Am I audible now? Please confirm. Please confirm whether my voice is audible. Please confirm whether my voice is audible.
Yes, you are audible now.
Okay, yeah. So today we are having the South Asian Global Intellectual Property Conference, and I welcome our Professor Dr. K. Shamla as the panelist and the adjudicating authority for this conference. She Dr. Shamla is the present chairperson of the South Asian Global Intellectual Property Summit, and we'll be initiating with this conference for this South Asian Global Intellectual Property Summit for the categories of faculty as well as professional. Uh, to start with, I invite Dr. Ankit for the presentation. Dr. Ankit would be speaking for the paper on the intellectual property rights. Dr. Ankit, the floor is yours.
Thank you so much, sir. Am I audible and visible?
Yeah, you're audible and visible. You may share
Great.
your screen.
Okay. Just a second, sir. I believe I can directly share the screen instead of uploading the file.
Yeah, you can directly share the screen, Dr. Ankit.
Yes.
Please do
Yes.
it first. Yeah, your screen is
Yes.
visible. Yeah. Yeah, you may go ahead.
Yes, sir. Just a second, sir. Because I cannot. Yes. All right. So, good morning, everyone, to the esteemed panelists and organizers of this conference. I'm Dr. Ankit Singh from Hidayatullah National University. And today, my topic for presentation is protection of IPR in the food and beverage business, a commercial perspective. So, please confirm if the slides are moving.
Yeah, the slides are moving.
Okay, so just to provide a brief insight of the F&B business, uh, roughly 10% of the total world employment is provided by the food industry, and it has seen a massive sales of 1.4 trillion in the in a world, and big brands sustained due to their unique products and strategic positioning, and it has become gigantic in the current years because many other allied industries are attached to it, like farming, agriculture, production, processing, packaging. So all these industries combined make the F&B industry a huge economic push for the world economy. So but this particular presentation is about the IPR aspect of the F&B industry and how IPR protection can give a commercial edge to the F&B owners, proprietors across the world, and how it depends on the jurisdiction and the outlook of the courts and policymakers, how these food entrepreneurs or F&B proprietors, perform in the market. So experiences of the business owners of food and beverage reveal that intellectual property is significantly underutilized in this sector. We all know that any idea regarding production or preparation of any recipe or any food product or any beverage, whenever it comes to an individual's mind, it becomes an intellectual property, but and it is freely available unless protected and monopolized. So an idea obviously is not copyrightable. It's an idea is not itself protectable, but it becomes someone's intellectual property, protectable intellectual property and enforceable intellectual property when it is protected and monopolized. And it depends on the cardinal IP principle that says that one cannot take any action against anyone who stole an idea unless your idea was protected in a tangible form. This is mainly a copyright principle. To kickstart, there are various case studies. There are various stories about successful F&B brands in the world, but this is a case study which gives us a fair idea about how big the F&B industry is and how important protection of intellectual property and IP assets for an F&B brand can be. So this is some figures for you. The Coca-Cola brand now currently stands at about $120 billion, and the recipe of it is a very tightly guarded secret, which is kept in a vault in Atlanta, which was specifically built for the purpose of storing the recipe secret of Coca-Cola. Apart from trade secrets, whenever a person craves a soft carbonated drink and they see Coca-Cola logo, they are reminded of the taste, and that makes them, make a choice in the market that yes, they want a bottle of Coca-Cola. And the shape of the bottle and the color combination, the overall feel of the product gives them an idea that they only will choose Coca-Cola whenever they are in the market instead of other soft drinks. So this signifies the importance of trademark, whose purpose is to communicate directly to the consumer about the origin, value, and quality of the product. So this case study is just to emphasize or underscore the importance of IPR, various kinds of IPR, whether it's trade secret, whether it's whether it's design, trade dress, how it builds a brand and how it establishes a recall value in the mind of the consumer. First of all, let's start with trademarks. We'll look at several aspects of IPR and how they can boost the businesses and the commercial edge of a particular brand. Trademark and trade dress is one of the most important aspects when it comes to F&B industry, because it's a mark that acts as an identity or a distinctive taste or experience which live on with the customers. And almost all aspects of a business are covered under trademark, whether it's a name or its logo, symbol, its unique packaging. Even when you hear some brand's name, you are reminded of the history, heritage, and legacy and the reputation of that mark. For example, Rolls-Royce, Adidas, big brands, old brands, IBM. So that particular name, that particular logo indicates the quality, and which plays a crucial role in influencing consumers' choice and purchase decision. There are certain examples in the market. Trade dress is an element of or under the umbrella of trademark, which basically means the unique shape, color, design, packaging, or the appearance of the product, which gives a clear idea to the person and removes any sort of confusion that they can have in the market when they are looking at identical products or identical services in the market. So trade dress aims to protect overall look and feel of a product as long as the proprietor can establish that such look and feel will immediately enable the consumer to associate it with product or the brand. Whenever you say, whenever you hear dairy milk, purple color, and whenever you hear about Starbucks, I'm talking about the F&B industry in particular. So the green ambience of its store. So this is sort of an indicator or the identifier or distinguisher in the market. So trademark is a tool to distinguish your brands from the other brands. So if a brand seeks to expand internationally also, it should consider whether its trademarks are present in foreign jurisdictions and whether they are otherwise registrable in those jurisdictions. So it is obviously recommended to the F&B business owners, even a person who are starting up with their F&B businesses, that they should be aware about whether their trademark is registrable under the laws of those countries they should not be barred by some sort of statutory provision. So it is very important to do a thorough trademark search before you give your business a distinct identity. You can't just randomly select a name. You have to do your research and come up with a name, come up with a logo which is protectable under the statutory framework of various countries if you wish to expand internationally. And most of these businesses are doing that, who are expanding particularly in regional areas in South Asia or particularly in the world. So there are two important factors to enhance trademark protection over food and beverage products. First is primary focus on the fixed number of market differentiators. Either you can be differentiate yourself through color only or shape only, or you can have a composite differentiator of shape, logo, color, name, because it creates an entire ecosystem, which are big brands things. Small brands are not that much into it, but definitely you have to focus. Even if you are a small business, you have to focus that what should be your distinguishing factor, whether it will be your logo, which remains with the customers, or anything like that. So consistent usage. Once you have distinguished yourself, you have to consistently be there. Otherwise, your trademark will be dissolved in the market, and it will be forgotten. So this is an important thing that you have to that F&B industry has to keep in mind. When it comes to patent protection, see, it is very underutilized, because normally when it comes to food uh, recipes, they might not get patent protection because the requirements of novelty and non-obviousness are so high. But definitely when it comes to food technology, unique ways of processing or packaging the foods, some jurisdictions might be amenable to provide patent protection to these unique innovative processes in the food sector. But when it comes to protecting the recipes as such, under patent, so obviously it's not a very valid or sort of a arguable proposition. But definitely F&B industry has observed that patent protection is rarely granted to recipes, but to ancillary products such as machines and innovative processes. There have been certain instances in various jurisdictions, such as famous chef Ferran Adria, who got patent on his famous olive oil caviar. So it depends on jurisdiction to jurisdiction how the patent offices of various countries look at their F&B industry and look at these entrepreneurs. So these are certain data. China, in the F&B industry particularly, emphatic increase has been witnessed in China, up to 500% patent filings, particularly in the food and beverage industry. Similar trend, not that much emphatic, but similar trend has been observed in Europe and US. And a US based establishment, Beyond Meat, has succeeded in obtaining a patent for a vegetable burger. So a product has been granted patent. So definitely it depends. It might be difficult in India to get patent on such products. So it is a critical perspective to look at things, that whenever we talk about patent protection, which grants 20-year monopoly, it depends on the economic perspective or economic condition, or how the F&B industry is faring in a particular country, how you can calibrate the patent protection mechanism to protect these entrepreneurs. So this is how we look at. So it is also interesting to know that prominent players like Nestle, Unilever, Pepsi, Coca-Cola, Kellogg, they are also, although they are very much aware and very much protected under the trademarks, trade dress, and they know how to protect their copyright, how to protect their ads and logos and taglines. And but when it comes to patent protection, these big brands are also moving towards, because patent protection itself is a very emphatic protection, 20-year monopoly over all the innovative process that you have, and it is very important, significant asset to have over your competitors. So these brands are also moving towards patent protection, which is in F&B industry, it is difficult to obtain, but they are still filing for it over their food products. Copyright protection again is a very important perspective, obviously more than patent protection. But it's difficult to obtain copyright protection in F&B business, because it is not an easy task to prove who was the original creator of a product. That is why prior registration of copyright with the Copyright Office is strongly recommended in this highly competitive market. Because once some chef has created a dish or a recipe, it's difficult to locate the original author, that who created, because it is a very old practice that chefs steal their recipes and then pass it off as their own. So recipes might not be considered as copyrightable subject matter themselves. Recipes themselves might not be copyrightable, but cookbooks and food blogs that carry a detailed analysis or detailed description of the recipe, they might be considered as digital content which can be copyrighted. So the copyrightability factor in the F&B industry is mainly governed by these factors, because threshold of creativity is quite high, because you just can't, it's just known ingredients, you just can't have write something down on a piece of paper and get copyright. So the threshold of creativity is quite high in F&B business. Many innovations mainly serve utilitarian functions, and it is very important in copyright to separate the utilitarian function of a particular product from uh, you know the functional aspect of it, right? So the compulsory requirement of fixation of an original work in a tangible medium. So these three factors are required when it comes to deciding whether a particular aspect of an F&B business is copyrightable or not. So these are certain challenges here also.
Dr.
Trade
Ankit,
secret yes sir.
Dr. Ankit, sorry to
Yes sir.
interrupt.
Sir.
Just conclude it within 2 minutes because you are exceeding your time.
It will, it
Then
will,
we'll
it
be
will.
moving ahead with some questions. Yeah.
It will, sir. It will, sir. So trade secret is the most, has emerged as the most effective tool, and we have already cited some examples. So trade secrets are something that there are formula process that a proprietor saves, protects, takes effective steps to protect them. So they can be protected by signing NDAs. Your employees who come across some information, so you can protect those through NDAs. So this is, in the F&B business, trade secret by far are the most important and effective tool when it comes to protecting your interest in the marketplace. Then these are certain other aspects, baker's rights. Due to positive time, I'm not going to go deeper into it, but cake designers, cake decorators is a contemporary trend that these are also argued to protect their own rights. And this particular case study of White House, where Obama's cake and Trump's cake was similar, that sparked a debate that a person who has exploited time and efforts to create a unique design of a cake, nobody should copy it. So bakers, cake designers, cake decorators, because cakes are the part of every celebration that we have, so these cake decorators should also fight for their copyright. So this, I included this in my paper as a separate topic of bakers rights and cake designers rights, which is also a part of a wing of F&B industry. So this patent protection, trademark protection, copyright protection in the baker's right perspective also I have covered. Recipes are itself are not protectable. Taste marks is a new trend that we have been seeing in various jurisdictions, in which trademarks may or may not be granted. It is difficult to grant or obtain taste marks in India because for trademark it should be graphically representable. So that's another argument that we can line up in favor of the F&B industry. So taste marks itself may protect the recipe itself, because recipe ultimately is nothing but combination of known ingredients. So how to protect a recipe? So this argument has to be crafted around this center focus point, that how we can protect a recipe, a chef who has come up with a unique recipe for a particular product. Other commercial aspects, F&B business proprietor must understand realize the corporate implications. Particularly, I have discussed social media campaigns, and when you are trying to market your products through influencers, so you must not impinge upon others' copyrights. You must not use someone else's tracks or songs to promote your own products, because there is influencer marketing in food products also, like any other thing. So these are certain things which should be kept in mind when you are commercializing your product on the digital marketplace, particularly through influencer marketing and social media. So there also your IP portfolio and your IP enforcement and your IP action should align with the standards of the jurisdiction in which you are operating. Then you have to record evidences whenever it is very important. These things I just want to focus on this, and I'll just conclude. You have to preserve the evidence of consumer feedback, reviews, press articles, and also diligently and aggressively protect their distinct identity. So once you have identified yourself, or once you are established in the market, you should continuously work to protect your distinctiveness. And for that, you have to record all the evidences, all the consumer reviews, all the articles that are published about you. That's where you will be able to establish your presence and your success in the marketplace. Recently, the case of Burger King, in which the new Pune a recent Pune shop was named similar as Burger King. So the Pune trial court ordered against the MNC, but then Bombay High Court recently stayed and gave relief to the US food giant Burger King. That gives us that how our courts are more pro business approach and protect the trans-border reputation, and they are in favor of protecting the businesses that are already established in the market. So this is one thing. So I would request, or I would also suggest uh, the audiences to look at these particular issues when it comes to understanding IPR issues in relation to F&B businesses. So social media marketing, when I conclude, F&B industry is going a structural overhaul, so it is very important to have a battery of IP lawyers to establish your IP portfolio and to be effectively present in the market. You have to study the consumer behavior, you have to monitor them, and you have to modify your presence in the marketplace, how they are perceiving you, how they are looking at you. So you have to completely be on your toes to realign your strategies with the your changing consumer patterns, because Gen Z is looking something else, Gen Z is acting uh, separately. So these are certain things that I wanted to uh,
Dr. Ankit, we can
yes sir.
come up with the question now. So
Okay
the
sir.
first questions, towards your presentation would be, what's your take on the moral rights? Because when we talk about the baker's right in the
Sir,
F&B, it's more towards the right providing towards the right over the trademark or in trade secrets, like
sir,
in intellectual property. So,
sir,
what about the moral rights if someone wants to claim in the copyright? So, what's
sir.
your take on it?
So definitely, if we are recognizing bakers' rights and if we are recognizing bakers as authors, definitely the rights that are available to architects, the rights that are available to any artists or painters, the same rights will be available to bakers. But the important point is whether we are recognizing them. Once we as a community, or once the court recognizes that bakers are someone who create copyrightable subject matter, they become author. And when they become authors, the special rights of authors that are available under section 57 will be available to them. And whenever someone, and they will have the right, both rights, paternity and integrity. So whenever someone they can claim that yes, this particular cake was baked by me, this particular cake was designed by me, this particular cake was decorated by me, they can claim authorship. Second of all, someone, if the better integrity, if someone tries to mutilate or tries to distort, they can also claim remedies that you should not do. But definitely my take is that once you recognize bakers as author, which is my particular contention, once you recognize them as valid authors, they will get all those rights that other authors get, like painters and writers and actors, or whoever can be
And
an author.
okay, and what are your suggestions for the legislatures in India for
Hmm.
the patentability of F&B products?
Sir, the thing is that business methods are not patentable, and since recipes are because food technologies and the back end technologies that are used in F&B businesses, which is basically mechanical processes, innovative mechanical processes that package the product or create some ingredients that are patentable. But when it comes to patentability, so according to me, Indian legislation should be as it is as of now. They should not think about patenting recipes, or they should not be patent. I'm just giving an argument that this is how what is the world is doing. But as of now, India does not need to do that. Whatever India is doing, innovative technologies, innovative packaging processes, that patent is still granted in India, right? Because we know that in India, the patent grant, the threshold of non-obviousness, novelty, and industrial application is very high. It should be kept that way, because otherwise, if you do that, the MNCs will eat our businesses, our small businesses. So in India, legislature should stay put.
Exactly. Thank you, Dr. Ankit, for your presentation. I
Thank
will
you, sir.
definitely look into your paper, and the panel will also look into your paper and provide you some suggestions in future course of
Definitely, sir.
time. Thank you. Thank you
Thank you,
so
sir.
much.
Thank you so much, sir.
So next, we are having uh, Mr. Muhammad Imran Ali from Pakistan. He would be representing the Islamic Republic of Pakistan, like for his paper. Yes, Mr. Imran Ali, over to you. You are not audible. You are not audible, sir. You are still not audible. Please unmute yourself. Unmute. You are still muted. No, you are not audible. You are not audible. Your voice is not audible, Mr. Imran. You are not audible till now. Mr. Imran, if you have any issue, you can just sort it out the issue. We can move with the next participant. Then we can take up your, yeah. Okay. So next we are moving with Dr. Hari Narayanan. Uh, Dr. Hari Narayanan. Yes.
It's audible, no, sir? Fine.
Yeah, it's audible.
Yeah. Can I start my presentation? My teammate
Yeah.
is all. Yeah.
Yeah. Please present your paper.
Yeah. One minute. I hope. Can you able to view this, sir?
Yes, your presentation is visible.
Yeah.
Yeah.
Fine.
Please start.
Okay. Uh, Good afternoon to all of you. So first of all, we thank you for accepting our paper. And this is one of the thing we are just trying. We are from Kerala. Actually, we are working under the Shankar Institute of Engineering and Technology, Computer Science Department. So we are working on machine learning. So we thought we are working means why we selected this topic. That was the first of all thing. This is the our topic. This agricultural innovation through integration of intellectual property and decision support framework. So the idea mainly we came like we are searching something related with this agricultural innovation. So we are working on that and how the cultivations are to be high. So we thought that okay, this is one of the interesting topic we got like some of the technology, some of the farmers, whatever that they are using. So we found that these can be incorporated, and we have identified some areas through that we started this study and we made this paper. So coming to this main topic, you can see here the subject like the impact of intellectual property on agricultural innovation is linked to framework helping the people to make decisions about how handle the land. So this is like land properties are there which can be incorporated, and also you can see we have something like genetically modified organism, the seed technology which we are using for of different plants. Also, it's different. So some of the things they have incorporated over here. So this is the to deal with the problem in society and the economy, the environment. Both the system use organized way to increase the farming output. So we are trying to generate more farming output through these ideas. So the following, like these are the main area we have identified, like the role of IP in encouraging new ideas in sustainable farming, broad method of sustainability, making land more productive, farming framework for helping make decisions, protecting the varieties of spice species. So these are the areas we have, like these are the things we focused over there, whatever the data we are having. So from there we got this idea, like means we came to this outcome. So the main issues you can see in an agricultural environment, like the key issues in agricultural, the environmental degradation and inequality, like food insecurity caused by unsuitable farming practices, then the rapidly growing populations and climate change necessitating innovative agricultural methods. So these are the points we have to focus. Like our populations are day to day increasing, and the climate change is also varying every day. So we have to incorporate those ideas, like we have to identify those things. So this is not like in all days we have the farmers have their own techniques, like the all technicians, all methods they are have focusing. So that focus areas are not possible now because we have changing all the climate and other things. So we came to the conclusion like this, the integration of hello sir.
Yeah, go ahead, go ahead.
So the integration of intellectual properties, right, and decision support framework for innovations, like so these are the things. So the integration of intellectual properties, rights, and decision support framework for innovation. So here you can see we are trying to continue with like this integrated means intellectual IP concepts and decision support frameworks. So what do you mean by decision support frameworks are nothing but these are the things like already we have a system which can be useful for making those cultivations and other things. Like we have different types of tools and organizations, like these tools can be utilized more, providing more data, like how the data to be done. And that is the our area, like mainly focusing on decision support framework. So we are trying to adopt those technologies here, and we have finded out some of the facts that may be useful in future. So you can see here the aim developing of climate resilient, genetically modified organisms and plant variants while ensuring fair resource distribution. So here another concept you can see here, the GMO. GMOs are nothing but which can be utilized, like these are the uh, genetically modified organisms whose genetic materials has been altered using biotechnology to introduce, modify, delete specific traits. So these are the things already there. So for that we have a set of properties, like there are some IPs they have taken. So those properties already taken and they have utilized it. That you can see in the study what we have think came. So you can see here the role of intellectual property, how the role comes over here to encourage the innovations, protect innovations like GMOs and eco-friendly agricultural technologies through patent and plant variety of protection. PVP is also there. So it's actually a legal framework designed to protect intellectual properties, right? Like the breeders who develop the new plant variety. That is the concept of PVP over here. And you can see the facilitate investment in high yield, climate resilient crops and suitable technology. So which will see these technologies when it comes automatically the small farmers they can make a group of or we can make a link, a collaborative link with a high team, so that will be good for their future also. Then you can come to the global reach, like licensing agreement can enable the transfer of drought resilient crops of water street regions. So this is also like the another key factor you can find out, like these agreements, or if somebody is having these types of IPs, so that will be like a symbol, like that will be good. They can also generate, means they can easily identify it. Okay, this is the crops a region they have developed, like what some name itself we generally go for that. So this is the thing we can come with that, like the key outcome, like increase the productivity. So and also we have some challenges. You can see high cost make IP protected technologies inaccessible to the small folders farmers. So that is another problem we generally face, or some of them when we started to studying, just we gone through like we have collected this through NGOs. So when we ask the NGO team that they don't know, so they are only know the names and symbols of the seeds and they are utilizing those things. And that is the problem, like it's already protected. So that the concept they have to be identified. Then coming to this decision support framework, the main purpose to provide a structured data-driven recommendation for sustainable farming practices, utilizing data sources like soil health, water availability, and social economic factors. So these are the things we will be focusing more on decision support framework. These can be improved. Like now we have not adopted that much. We have only taken the data and we have driven. We came to a conclusion like these are the factors are there. But in future we can have a lot of feel like we in this area we can include machine learning concepts, more machine learning concepts. So that can be good. Like we have a lot of research area we can focus over here, and we can make a collaboration over here also. Then the key contributors like optimize the crop selections and placement for specific agroecological zones. Like we can identify some regions, and through that regions, like some specific areas near to the coastal area, what type of cultivation we can make, or if it is a heavy raining places. So we can consider like how these things are comes, and that can be utilized over here. Then it's ensure that the holders, farmers, and underserved regions benefit from the innovative technologies. That is one of the things. Then when it comes to the integration part, integration of IP and DSF model. So the synergies between this IP and DSF, like IP system-driven innovations by protecting new technologies. DSF ensure the technologies are strategically developed and equally accessible. So this is the concept we are came like here you can see the IP system which will innovate. It means a new innovation comes, then those things can be made into IP, and already some IPs are there. So that also we can bring into this DSF model, so which will encourage the production and other things. Then the main proposed model features like patent protection for GMO and resilient plant variants, tied licensing model to support smallholder farmers, data integration for localized climate and soil analyst, mechanism to reduce the cost and ensure fair technology access. So this is the proposed model. Like we generally go for like in a IP framework. You can see the patent protection. Like this is a safeguard like GMOs to incentive and R&D investment. Then plant variant protections we can use, like how the developers specifically plans, which type of plants should be taken out. Then licensing mechanism we can focus over here. Then the main objective, you can see the promote the adoption of advanced agricultural technologies while balancing cost and accessibility. Here you can see that we generally do a data collection integration. Then we have a recommendation generation that maybe means that is used with the help of DSF and other things. Then when it comes to this and the farmer knowledge, that is also we have to take care. So all these things comes together, and we can have means sometime we can go for this IP protection and licensing. That will be good. Okay, so before deployment and some factors we can focus more on this, then it will be good, like we can generate more productivity that we will see. So the proposed model decision support framework, what we can do, we have a data integration. We have to aggregate the soil, climate, and socioeconomic data to be recommended. Then climate and soil
Dr.
analysis.
Narayanan, Dr.
Yeah.
Narayanan, sorry to interrupt. You can go ahead with the solutions
Oh, yeah.
before.
Fine, sir. Fine, sir. I am coming to that only, sir. Only few slides are left. So we have this is the experiment part we have done. Like we have a means normally we have divided the entire team into three, and this is the control group where the traditional farmers are there without the IP and DSF tools. They are only using traditional methods, and then when it comes to the experimental group, they are using DSF technologies like design technologies they are using, decision support techniques they are using, like how to farming, like the water, how the other things they are using. Then the other group, what we have find out that they have using like the IP, but they are not know about they are actually using this IP technologies, but they have using something seeds which are IP related. I already IP took. So that the things we have collected, and from there we have come to this conclusion. So this is the crops yield, and we are validating all the impact of DSF, and this is the combination of we are having. So the key things what we have find it out, like you can come to this. These are the parameters we have to. So the three groups already there, like crop yield. So you can see the adoption changes, like when it come to this experimental group. If you see the traditional, in first group they are only have a traditional mindset, but when it come to the group 2, they need more training, like they are utilizing some DSF technologies, but they are not utilizing the IP concepts. So they can improve the technologies, and they can have something like they can increase their income. Then the experimental two comes when it comes to like the IP cost and initial investments are required. See, we know that for doing a patent, we need if an individual or something, we need to have cost factors are there. So that may be one of the reason to increase, like the initial investment are required. One who finded out those concepts, that is there. So this is the outcome we got, like the average, the income of farmers, that the main focus we will be having. So in experimental 2, we have pointed out that the 35 percentage they are increased their income, but compared to this experimental 2, they are not adopted this IP concept. They are only used the normal like DSF concepts, decision support system they have adopted, but they can improve later technologies. So they have, you can see here the average yield percentage. According to that, we came to this is the income. So the challenges what we have means challenges and opportunities over here. So the high initial cost and licensing fee for small farmers are there. Then administrative and legal barriers in implementing IP system. So they don't know the how to adopt it, and how these things to be a concept, and how much cost. They are not at all aware about these small. They are only know that these are the seeds are good, okay, but they are not aware about the other part. Then the opportunities are there, like foster public private partnerships to lower technology cost, develop an open data platform for small holders friendly and decision support tools, and encourage collaborative framework for equitable access to innovations. So here a lot of chances are there, like now the era for machine learning and AI. So we can have a lot of technologies can be incorporated over here. So if we have a collaboratively, if you come to this concept like decision support systems and other things, so through that we can able to produce the results. So the conclusions, like it's an integrated IP and DSF frameworks are transforming and suitable agricultural, enhance the climate resilient, food security, and economic equality globally. The future direction, you can see, incorporate AI and big data for real-time decision making, policy adjustment to improve the accessibility and adoption of innovative technologies, increase focus on biodiversity, conversation, and equality resource distribution. So these are the things. These are the reference we took, and these are the things from my side. So, thank
Thank you,
you.
Dr. Narayanan. Like one question to you would be how DSF model can help you in in integrating the patent protection and reducing the cost in agricultural patent.
Sir, here we can see that the decision support system, like tools, are there already. That actually used for the business and healthcare. Everywhere we are using those types of technologies. So these decision support tools can tailored address the specific challenges and opportunities in agricultural and intellectual property management. Like we can have a climatic analysis we can do over there. Then soil health monitoring, then integrated pest management, then crop selection, then yield prediction. So these are the things where we can have these IP integrations. So that will be useful for further more understanding. And also, sir, this is the concept I want to tell you, that these decision support systems are more. We are focusing on machine learning based analysis. So where we are easily able to identify more areas through that that can be adoptable for the farmers. That is the way, sir.
Okay, thank you, Mr. Narayanan. I will definitely look forward to your paper and will
Sure,
suitably
sir.
provide some suggestions and
Yeah,
recommendations
we
to you.
need your suggestions. Thank you, sir.
Thank you. Now we go ahead with Dr. Sushani's presentation. Dr. Sushani, floor is yours. Yes, Dr. Sushani.
Yeah, hi. Good afternoon, everyone. First of all, it's Dr. Suhasini. Good
Suhasini.
afternoon
Yeah.
to everyone. This is Dr. Suhasini from School of Law, Bennett University. And my topic for today's presentation is protecting the unseen, the case for strong trade secret laws in India's IPR regime. So here, when we talk about trade secret, so this is a kind of very important topic from the perspective that this component has been overlooked, especially if we take into consideration Indian scenario. If we talk about in general perspective, also the first thing which comes in our mind when we talk about IPR is patent, copyright, trademark, or you can say design, or maybe to some extent geographical indication also. But trade secret, which is a kind of very important aspect, has been quietly underpinned, and it underpin much of our innovation also. It encompasses certain confidential information which is very important for the business to survive. And if we take into consideration Indian circumstances, it is mostly dependent on different factors other than having a robust law. So keeping that in mind, today's topic of mine is focusing on why there is a need to have a strong trade secret laws in India's IPR regime. So, moving ahead with the definition, first of all, what is trade secret? So, as the name itself suggests, there's a word secret in it. Any confidential business information which is providing you an edge over your competition. Maybe there's some formula, maybe there's some algorithm which you are using, maybe there's some secret recipe which is there, or maybe there are certain data of yours which is very confidential and which is very much important for your business to go up, and it is also very important from your perspective to stay relevant in the market. And the moment it becomes leaked, there is a violation of your trade secret right, there is a downfall in your business, or maybe at a larger scale you may not even survive because your formula is out. And if I have to give examples of trade secrets, so we have seen many examples. The best known example is of Coca-Cola, which is also known as merchandise 7x formula, which is so secret that it is only known in between, I mean, the information is between two or three employees only. As per the report, it is between two employees only, and they make sure that when these two employees are traveling, they are not traveling together also, so that if something happens to one, the information remains there. And this information has been kept in a secret vault in Atlanta. Also considering the mind, and this is the reason why Coke has been able to survive for last 130 years. Many beverages have entered into the market, but none has been able to beat the Coke. So that is one thing. Similarly, if you talk about Google algorithm, Google use certain algorithm to stay relevant in the search engine business. And there are many search engine business, but why still we go and say, okay, Google, let's search on Google, because Google would be giving you the information. And Google also, in order to keep it secret, has been, on regular basis adding certain changes to it so that it does not come into public domain. So it is a very important aspect from a business to survive. And also, maybe the other example can be KFC. So KFC chicken or whichever is being cooked, they uses some sort of 11 herbs, and what those herbs are, it is very confidential one. We see many markets in Indian business also. You'll like go to any city, you'll find King's Fried Chicken or some similar name sounding to KFC, but the recipe or the food which you get at KFC is different from what you get at the other place. And this is why, because why it is so, because KFC has been able to preserve its formula. So trade secret for any business in a competitive world, from Indian perspective or from global perspective, it is very important to protect it. And how trade secret fits in IPR? It is, you can say, complementary to patent, copyright, and trademark. It is also having certain advantages. Maybe Coke is also having a trademark, well-known market is there. But Why they didn't go for patent, why they went for trade secret? Because the moment they'll go for patent, after 20 years it will come in public domain, and the moment it's in public domain, everybody knows the formula, so the relevancy will not be there. So considering that trade secret, even though in the era of patent, copyright, trademark, AI, digital world, where we talk about each sort of IPR, trade secret has a very own relevance, and it plays a very important role. And it is important for the industries like pharmaceutical, manufacturing industry to have a robust trade secret law. Now, when I talk about the current scenario in Indian market, so we don't have any dedicated trade secret legislation in India. It is mostly governed by Contract Act. It is mostly governed by the common law principle. It is governed by judicial precedent. Also, to some extent, it may fit in criminal law also, where criminal breach of trust is there. But don't we think that instead of going and figuring out different legislation, we shall have one legislation which is protecting our rights? To some extent, it is also protected under anti-competitive business, but no robust law is there. And in contract also, you go for non-disclosure agreement, you go for confidentiality agreement, but then there's a section 27 which refers to the same. But this section also says that any restriction and restrainment of trade is void. So considering that, to what extent you can restrict other persons' contractual employment also comes into picture. There's lack of enforcement mechanism for sure. Limited awareness is there. Limited consistency is there. Even let's say I may feel confident about you guys, and I'm not aware of this trade secret thing, and I told you my recipe. You went ahead and you told it to some other person, and the other person is coming up with a new product, or maybe they are trying to brand my own product. But here I don't know that my trade secret has been violated. There are some other business also running the same thing. So considering that these are the current state of trade secret protection in Indian market, and international perspective, if we talk about, so from Paris Convention to TRIPS and different nations, everybody is having or is focusing on the trade secret. For example, Paris Convention, the major agenda 10 bis is a protection of or uncompetitive, or you can say aspect, where it is directly not mentioning about trade secret, but it is somewhere providing a protection. TRIPS agreement mandates members to protect undisclosed information, but again, trade secret word has not been used. If you go and look into EU directives, so 2016, they have a standardized trade secret law across the European Union. Similarly, US Trade Secret Act, Defense Trade Secret Act is the latest one, which came into 2016. Before this also, they had certain trade secret laws. And in fact, in US has also discussed this with India, that you need to have a trade secret law. And other than these countries, if we look into or take into consideration our South Asian region also, China is having a very robust trade secret law. Other than contract, company laws and all, the courts in China have clearly defined, and they have been saying that these are the things which falls within the definition of trade secret. If you do this, this is a misappropriation of trade secret, trade violation. And what are the repercussions which is there if you take away someone's trade secret? And the lessons which we can take in from our neighboring countries, specifically if I'm referring to China. And also, if we take into consideration EU, US, TRIPS, Paris Conventions, and everyone, there has to have a legal clarity and enforcement. Role of digital security and cross-border cooperation has to be there. Why there's an importance of strong trade secret laws? Because it encourages innovations and R&D investment. It protects small and medium enterprises from corporate espionage, especially when we are talking about Make in India, and we are talking about promotion of SMEs and all. Then there's a need to have a trade secret law. It also enhances India's competition in global market. And when, like, LPG is there, market is open, if we go somewhere, at least we shall have a law of our own, and accordingly we can request the other countries also to have to give a equal protection to Indian trade secret. It is also safeguard against cyber theft, misappropriation in digital economy. The very recent example of this could be Nika. The Nika CEO left the company. Then Nika filed, I mean, one of the major leader of Nika, or you can say head position, left the company, and he joined, if I'm not wrong, this Tata one, which is there, West Side, the online brand which is there. So they joined this particular product. Now Nika has filed a suit before the court saying that he went, Some data of mine also went with him. Also, he was holding a very prominent position in Nika, where all the informations were there with him, from ranging from customer lists to product marketing strategy, business, and all. So there shall be some restriction where they are not using my, business ideas, business strategy. So considering that, this case also brings up a very important aspect, why we need to have a robust trade secret law. Yeah, it is Tata Click. And then the need for stronger trade secret laws in India. Growing knowledge driven economy, IT, biotech, and AI require robust framework, preventing misappropriation and high stakes collaboration. Nika is the best example of this. Aligning with global standard to attract foreign investment also, because you need to give them this confidence that you come to Indian market, your secret will be there, your product would be safe, and enabling faster dispute resolution to reduce legal uncertainty. Recommendation for India's trade secret regime. So before I get into recommendation, the 22nd Law Commission report has also highlighted the importance to have a trade secret laws in India, and they have given certain recommendations. They have also drafted the law, you can say they have defined what is trade secret. So considering that, now the Law Commission is also thinking of, or is of this view that there has to have a law. So introduce dedicated trade secret legislation first of all, define trade secret and misappropriation clearly, and this will also be in align with our IPR, new IPR policies also, provide civil and criminal remedies, strengthen enforcement mechanism. You shall have a specialized IP course, digital forensic capability which should be there, encourage business practices like mandating non-disclosure agreement and confidentiality clauses in employment, but at the same time making sure that these non-disclosure and confidentiality agreement is not violating somebody's right to practice their trade. Now, this is what is the conclusion, that trade secret are the unseen protectors of innovation. Strong laws are critical for India's transition to a knowledge based economy. Harmonization with international standard will position India as a global leader in IP, and let us pave the way for stronger trade secret laws to unleash India's true innovation potential. So, this is from my side now, if there's any question.
Thank you, Suhasini. The first question to you: what's your take on the harmonizing of the laws on the trade secret and making a consolidated code over it? Because as you just
Okay.
mentioned, for yeah, yes, go ahead.
Okay, so when we take into consideration, as I have just stated, even if there are cases in Supreme Court of India, they have been taking reference to different laws. Sometimes they are referring to contract, time they are referring to criminal law. And when we look at international perspective, TRIPS and all mandate you to have a law. And TRIPS and all mandate you to have a proper protection for the same. Now, when you are not having a specific law and specific court per se, let's say, which is dealing with the same thing, which may not have even an kind of special, like nowadays we are focusing on specialized court so that they can better deal with the matter. So considering that, since it is an untouched area, the court will also help in making understand people what it is. Maybe it can also create awareness. And second, having a robust law which is with respect to global position is, in the era of global information transformation from one place to another, if we are going to some other countries, we can say that these are my secret and I cannot disclose it to you, and our laws gives us the protection. Similarly, if some other country is coming into India for businesses, we cannot force them to disclose their laws. So there has to be a law which is in relationship with global laws, so that it is good for both business from Indian perspective and from international perspective.
Thank you, Suhasini. I will look forward to your paper in a more
Sure.
detailed legislative recommendation.
Sure, and we'll wait for the suggestion so that I can incorporate it in paper. Thank you.
Definitely, definitely. Thank you. Thank you so much for your presentation.
Thank you.
One announcement for the participants: those who are done with the presentation, they may leave the room because we have very limited slots. At once, only 10 people can join it, so that it will enable the other participants to join. So, coming up with the next participants, we are having right now Mr. Muhammad Imran Ali. Mr. Ali, if your mic is okay right now, still now you are not audible. You are not audible, Mr. Ali. Mr. Ali, check whether the settings are okay with you. You are not audible, Mr. Ali. We have to move ahead with our next participants then. That would be much better. Yeah, next we are having Mr. Siddharth. Mr. Siddharth Das. Yes, Mr. Siddharth, you may present your paper. Mr. Siddharth, you are not audible. Mr. Siddharth, you are not audible. Okay, Mr. Siddharth is facing some network issue. We may move ahead with Garima Panwar. Miss Garima Panwar.
Audible? Am I audible?
Yes, you are audible.
Okay, I'll present. Just a minute.
Yes.
Is my presentation visible?
Yes, it's visible.
Uh, yes, sir. So, if I may start. So, my topic is from local to global, assessing the legal framework for geographical indication and with special reference to state of Uttar Pradesh. I am presenting this along with Dr. Anubha Dwivedi, and my name is Garima. I'm an assistant professor at HNLU Raipur. Now, whenever we talk about geographical indication, now though the concept has come from France and Portugal, and over the period of time, we have evolved from indications of source to appellations of origin and now to geographical indications. But there are certain aspects which are still left untouched, or rather, there are so many challenges which are there in geographical indications enforcement. Now, if I have to give you just one single statistic, like there is a global trade initiative report of 2021 which says European Union has 3,400 GI registered GI. China has around 7,247 registered GI till 2021.
But what about India? India till date, till as per the last figure of ministry, of government of India, we have 643 till July 2024. That's the number. Now, the question arises, what exactly is a geographical indication? Now, there are three things to be understood over here. Geographical indication is for a good. Second, this geographical indication is having this particular good is having certain quality, characteristic, and reputation. And this is essentially due to a particular location. Now, the best example of that can be a Darjeeling tea. Darjeeling tea, it's a good. There are certain quality, characteristic, and reputation of the type of leaf, the fragrance, and that quality is because of the terrain of that particular location, that is Darjeeling. So the question comes, why should we even protect geographical indication? So the first justification that definitely comes is that it's a socio-economic tool. The second comes is that somewhere the other there is an institutional, it is institutionalizes the collective reputation. Even it gives a base and all kind of it acts as a marketing tool for the producers who are there, and definitely it acts as a brand. Now, when we are talking about geographical indication in India, now before the TRIPS agreement, India being a WTO member, we were a part of the entire negotiation when the negotiation was going with respect to geographical indication. How India was protecting before our GI Act of 1999, that is even pre-TRIPS or the enforcement of TRIPS in India, we were managing through unfair trade competitions, passing off, and definitely trademark. Needless to mention, US is still protecting through trademark. Now, post trip, we definitely had this particular legislation. However, because we are complying to TRIPS agreement, there's one particular challenge which we are facing internationally is the enforcement of Article 23 of the TRIPS agreement. Now, to give you a brief, Article 23 of the TRIPS agreement says that there should be higher level of protection for wines and spirits. Now comes the question: higher level of protection only for wines and spirits? What for the other goods? Now, specifically, if I have to mention over here, basmati rice. Now, basmati rice, it grows in the foothills of Himalaya. There is a constant tussle, not just within India, as to which all state should get the protection. Like a few years back, Madhya Pradesh was contesting that basmati should they should also get the protection of GI for basmati. On the other hand, there are negotiations that whether the neighboring countries should also get the GI protection. So this is where the concept of homonymous indication is.
Yeah, go ahead, go ahead.
Okay. Okay. So another thing that comes into picture, January side. Now, for January side, when we talk about uh, is just a minute. Sir. So whenever we talk about genericide is the concept, the entire basmati rice, it is somewhere or the other, it is believed that it will become generic. And even Darjeeling tea, many cases in US, they have contended that consider Darjeeling tea as generic, because the moment it's considered as generic, it will neither be protected under GI nor will it be protected under trademarks, and that will be beneficial for law. The next concept that comes into is that no doubt we have a GI Act. But over here, the question comes, they provided for the registration procedure, but there's lack of awareness. Now, the Act says that there is a registered proprietor and there are authorized users. But most of the authorized users who are actually using that particular registered GI, they're not even aware as to what are their rights, how they can actually market their product by using the logo or by just writing down that there's a registered, that GI is registered. And another thing is the post registration quality check mechanism. Now, once a GI is registered, like we have the incident of Tirupati Laddu recently. Now, Tirupati Laddu is a GI, but despite of that, no one can verify whether the quality which was initially promised is still there or not. Now that has become more of a political issue, but this questions the quality which is promised at the time of registration, whether the same is maintained or not. Now, the coming to Uttar Pradesh. Now, the reason I've taken Uttar Pradesh is for specific for specific development schemes which they have. Now, I'll give you a background as to what was the initial point in with respect to Banarsi sari. Now, Banarsi sari, one of the epic fabric and having a historical significance, that the patterns are based upon the Persian and Mughal influence which is there. And secondly, it takes around minimum 15 to more than 4 months to make one particular, even a sari of like the Banarsi sari. Now, because this is expensive and being a handloom sari, there comes a question that there's a lot of time, labor, and energy, electricity even goes into it. This is a very high cost product. However, there are cheap substitutes in the market, and specifically the Chinese silk which is being substituted, and not just the producers but also the local the middleman and all, they are selling the cheap substitutes in the name of Banarsi sari. As a result, it had hit the producers and the manufacturers, and they gradually shifted to some other profession. So this was observed by the state of Uttar Pradesh. If I have to mention, as per the registered GI list shared by Government of India, till July 2024, there are 77 registered GIs in name of Uttar Pradesh. However, there is one of the news report by EPIDA, the agriculture produce the organization. It, as per it, there are 36 new GIs registered only for these products which are originating from Uttar Pradesh. So this is where the leap has from 2009, from 1999 when this act came till 2024, there are only 77, and now there are 36. And this is specifically because of the new policies which Uttar Pradesh came up with. And in addition to that, there are also many potential GIs which are there. I have to mention a few. The newly registered is Agra Ka Petha, or even there is the Banarsi Pan. And when we come to the potential GIs, there's Fatehpur Sikri's Namak Katai, Aligarh's Cham Cham. So there are a lot of things which are coming into picture. Now, coming to what are these Uttar Pradesh policies which are there. First of all, Uttar Pradesh established a handicraft development and marketing corporation. Now, this corporation had established Gangotri emporiums all over Uttar Pradesh, and these Gangotri Emporium remove the middleman and ensure that the goods are procured directly from the producers and are being sold in the market. Now, these kinds of emporiums are also there in other states of India also. So this is something which is highlighted in other, or which is commendable for the other states, like even it's there in state of Madhya Pradesh, in Punjab, even in Chhattisgarh. Now, the another policy which is there is handloom, powerloom, silk, textile, garment policy. Now, this particular policy is specifically focusing um, the backward areas of or the backward regions of Uttar Pradesh, like Bundelkhand and all, wherein government is providing concession with respect to electricity, with respect to certain textile industries, so that they can manufacture more products. And eventually, when there are more stakeholders in the market, there will be or when there will be more producers, then they'll get more incentives from the government. There will be more production. The last scheme which government, the state of Uttar Pradesh has launched is, which should be a model for other states also. One district, one product scheme. Now, one district, one product scheme says that every district should aim at developing or getting registration for at least one product of
Miss
theirs.
Garima, Miss
Yes, sir.
Garima, move ahead with your solutions.
Yes, sir. So I have divided my recommendations in five levels. The first is international level, wherein I'm saying that there should be bilateral and plurilateral agreements with other countries for protecting geographical indications, and the negotiation should be there even to expand Article 23 of the TRIPS agreement. Now, the national level, I am proposing that post grant of any particular GI which is being granted, there should be a quality check mechanism, and there should be nodal agencies at three tier level, at the district, at the state, and at the center level, which should be established, so that these nodal agencies will ensure that is there any specific help which are required by the registered proprietor or authorized users for registration, or for any other help for quality check mechanism and all. In addition to that, there should be personal relation officers in all these nodal agencies. And in addition to that, there should be a regulatory authority, an administrative body which will be avoiding any kind of misuse of GI, which is there after the registration of GI. In addition to that, now GI is not just one ministry's responsibility. There are so many goods, so different ministries and departments should come together and for promotion of geographical indication and protection of the same. Now, the state level, like definitely one is that there should be that one district, one product scheme which should be launched by other states also. There should be an e-Suchna kiosk or helpline numbers which should be there for all these producers and the authorized users, so that they get to know about the opportunity. If there's a regional fair where they can showcase their art, or if there's any other research and training institutes which are established by the state for skill development, then that will help. Another is barefoot lawyering. Now, barefoot lawyering is if you are teaching one individual from that particular community as to what is GI, how the same is protected or marketing, let that individual further train the other persons. This is where we are saying they become a kind of lawyers and propagators for protection of GI. Another is at producers level. Now, there should be cooperations amongst the producers, specifically with respect to quality maintenance, and with respect to that how much amount of goods should be produced, the bulk, and also that they can eventually think of how to maximize their profit. And the last is at the consumer level. The consumer should also be aware that because of them, a particular good doesn't become generic, or they should be aware as to what that even the GI can be a particular brand and promote these GIs. That's it, sir. Thank you.
Thank you, Miss Garima. One question towards your presentation is how you feel that India should enforce more reversed mechanism for the registration of geographical indications, because when we see the statistics, we see the countries like Germany is having more GIs in together. When we count, like they are having more GIs in all together Asia combined.
Yes, sir.
So, how you take these as a recommendations? Like, what are your solutions towards this? What are the mechanisms India should take into?
So, um, first of all, if we are saying that there should be more registration, then in that case, there has to be more registration, not just within India, but also outside India. Like there are so many countries which are registering their GIs in India. Second thing, when we are talking about is like in the state of Uttar Pradesh, we are launching one district, one product. So somewhere or the other, there is an awareness which is there amongst the producers and the authorized users also. So somewhere or the other, that awareness and one district, one product schemes from the government side will also help out. Thirdly, there need to be amendment in the GI Act, specifically with respect to the post quality check mechanism. When a product goes outside, it's the reputation of India and that particular state you are carrying out. So that's how you will be able to promote more or get more registration.
Thank you, Miss Garima. We will definitely look into your paper and we'll seek more recommendations and also will suggest some changes.
Thank you, sir.
Thank you. Now, next we move ahead with Mr. Siddharth Das. Siddharth Das, yeah, your voice is not audible, Mr. Das. Yeah, you are audible now. You are audible now. You may present your paper. Again, you are not audible. Again, you are not audible. If you are facing network issue, you may turn off your camera. Your voice is not audible, sir. Your voice is not audible. It's not audible. If you're facing network issue, you may join little late. We would be continuing with some other person. Your voice is not at all audible. Yeah, so next participant would be Palak Rajpal. Miss Palak,
I'm there.
we'll be moving ahead with your presentation.
Yes, sir, sure.
Yes.
So may I present my BPT?
Yes, yes, please present.
So just a second, it's getting uploaded. So is it visible?
It's not visible, Miss Palak.
Okay. It's processing, maybe that's why.
Please be fast.
So I've already uploaded. It is just processing. I hope it's
Yeah,
visible now.
it's visible now. Yeah, go ahead.
Okay, sir. So first of all, I'd like to thank you for allowing me to present my paper. My topic is Metaverse, Avatars, and Personality Rights, a critical examination with special reference to trademark implications and challenges. So, starting with the introduction. First of all, let me tell you, metaverse is just a combination of the real and the virtual worlds. It is not something new. In 1992, author of a book stated that a virtual world will be called the metaverse, where people will interact not in real life but in the meta space, just like we do in video games. This is described as the next evolution of the internet. So far we have evolved from what was there as a worldwide network to now a metaverse where we'll be virtually interacting with each other in the so what is my perspective here is businesses in the metaverse are going to be free to sell virtual goods and services, and brands have already started promoting their goods and services on the metaverse in the digital realm. They have started developing strategies to suit this digital realm. They have started to register their trademarks. They have started buying lands on the metaverse. Hence they have acknowledged that the next evolution from internet, like now the marketing is done through influencers on the internet, the next stage would be the metaverse. uh, Apart from this, not only brands but individuals too have realized that the next base of interaction in would be the metaverse, hence avatars. So what are avatars? Avatars basically mimic real individuals or fictional characters too. So for example, a avatar on the metaverse could mimic me similarly with my name, or It could mimic a fictional character, for example, Harry Potter. So that is what a avatar is. Now, when we talk about avatars, they interact with each and other on the metaverse by representing other people. So if my avatar is there on the metaverse, one can suppose that it is representing me there. Hence, they are like gateways to the metaverse. So if you have to enter the metaverse, you have to have an avatar. So my paper focuses on challenges faced by brands as well as individuals when it comes to protecting their trademark and personality rights in the metaverse. Now, before I move ahead in personality rights, what I'm going to cover is image rights, because I am talking about intellectual property, and I'll not go into detail with respect to privacy rights, which are also a part of personality rights. I'll just keep my focus on image rights, which a avatar represents in the metaverse. So, first of all, let us discuss trademarks in the metaverse. Now, we have realized that metaverse is being used for advertisement of products online in the metaverse. But now, how are brands using it? What are brands seeing in it that they want to represent themselves in the metaverse? So basically, consumers have opportunity to buy virtual goods on the metaverse. It can be a copy of the actual good in the real world. So what brands are offering in the metaverse are basically counterparts of those goods, which are in form of non-fungible tokens, NFTs. So what a consumer can actually buy on the metaverse is a NFT, not the real product. Other method that brands have used is collaborating with online games and platforms. So for example, there is an online game, a brand can collaborate and have advertisement in that game itself. They can have shops. For example, if Nike wants to promote its shoes, it will collaborate with an online gaming platform wherein there would be shops of Nike or boards of Nike. So that is another way. The third thing that the brands have started doing just to gain popularity is that they have started buying lands also. So these are the three forms through which brands have tried to get a place in the metaverse for themselves, so that they can interact with the younger generation. So what is the aim of the brand here is interaction with the younger generation, because that is the generation to which they are trying to sell their goods. That is their target audience. Getting to the next slide, these are a few examples. So on the first picture is of a Nike metaverse shoes. So Nike has already filed for a trademark in the US Trademark and Patent Office, stating that they would like to trademark they want a trademark in the metaverse for their products. So first is the example of that. The second one is that in 2021, 9 NFTs were released by Dolce and Gabbana, which were also sold at millions. Dolce and Gabbana is a fashion brand. Then the third example is of One's virtual world. So One's has made a virtual world wherein people can go buy things and interact with each other. That is how it is offering to promote its product on the metaverse. Going to the next slide. Now we understood how the brands are using trademark. Okay, we have understood that the brands want to make a place for themselves in the metaverse because they see that there is potential of growth. That is how their money is going to come on a later stage. But what are the challenges that one might face on metaverse when we talk about trademarks? So the first thing is, when we talk about trademarks, there are always defined classes of goods when we go for registration of a trademark. That all of us are aware of that. So when it comes to a trademark registration on the metaverse, what has been currently used is digital platform. For example, in the US, when we say that Nike is registering for something, it is registering under the class of virtual goods, softwares maybe. So when we say registration, all the registrations will be under the same class, which would be a problem. Secondly, there is no way of identifying the source or the authenticity. So probably if I'm playing a game and there is a Nike shop there and I go and buy a shoe there, NFT of the shoe, of course, there is no way for me to identify whether that is authentic Nike shoe, authentic Nike shoe NFT or not. There is no way to identify that. The third problem is filing of applications in bad faith in bulk. So now, once a person has realized that metaverse is a place which will potentially give them a lot of money, many fake registrations would come up. Now, brands like Nike, Puma, Dolce and Gabbana, they are global brands and they do know the importance of metaverse. What about local brands? India has had no registration of a trademark in metaverse. So, local brands have no idea that there is metaverse that exists. So, if a person sees the potential of a brand growing at a local level, they might file a application in bad faith in the metaverse for trademark. Apart from that, for now we have local laws for infringement and no laws that talk about what happens if there is infringement of a trademark in the metaverse. This I have highlight. I would like to highlight a recent case that has taken place. So recently, Hermes claimed that there was a person, Mr. Rothschild, who have infringed their Birkin trademark. Uh, One thing to be noted is Mr. Rothschild did not copy the Birkin design or anything. He just released digital images of tote bags and he notably named them as Meta Birkins. These Meta Birkins were sold on the metaverse. That is when Hermes claimed that this is an infringement of their trademark Birkin. This went to court, and the court apparently gave the decision in favor of Hermes. But I have highlighted this case because this tells us that there is actually the brands are actually realizing the importance of metaverse now, and infringements have already started taking place in the metaverse. Hence, solutions are required for the same. Now coming to personality rights, we have discussed trademarks till now. When it comes to personality rights, so personality rights are basically legal rights to protect a person's identity and image. This includes image rights and privacy rights both. As I'm focusing on trademarks, I'll focus on image rights. So the question of image right comes up when avatars in the metaverse copy real life individuals. It can be personalities, it can be normal people as well. So when one is copying an avatar, there is no way of identifying who the person behind that avatar is. Till now, there has been like no way to identify that. So there are three ways in which image rights can be distorted in the metaverse. Firstly, if it is a complete copy of a real life person, famous or general anyways. Secondly, through endorsements. Now there can be multiple endorsements on the metaverse, and brands or even small local companies can use personalities of individuals who are famous or not in the metaverse without realizing the
Miss
implications of
Palak,
that.
move ahead with the conclusion part.
Yes, sir, sure. So when we talk about the conclusion, what I have come to the conclusion is that metaphors is a new frontier of innovation. It can be helpful for brands for their promotion, and in a way they can connect to the younger generation and sell their products in a very easy way. However, it is essential for us to modify certain legal frameworks to ensure that the intellectual property right on metaverse is protected. This will promote a reliable environment. This would protect the environment. This would make the place a safe place for us. I have a few suggestions for the same. The first one is for the protection of trademarks. What we can do is class identification. Now, as I said, if there will be one single class, every brand's product would be protected in that single class only. So, one initiative could be identifying different classes of trademarks on the metaverse for their protection. Secondly, is KYC or know your customer. So, when I am making an avatar on the platform, I should be asked to do the KYC. As of now, whenever we register for an online game or represent ourselves as avatar on online games, this is not the case. Hence, there is no way of authentically identifying the person or the source. The third is blockchain. So blockchain would ensure authenticity. How is that? We if we save the data in blockchain, it cannot be copied. So once the KYC is done, this would by saving the data in the blockchain would ensure authenticity and a reliable environment. Given that there have been crimes also in the metaverse now, to to identify the source of that, these methods could be helpful. That's it, sir. Thank you.
Okay, one question from my side, Palak.
Yes, sir.
How you deal with the like characterization, as you just mentioned that the people are coming up with the characterization of a virtual characters in a
Yes, sir.
metaverse, and it is infringing like the trademark. So in such cases there are also a term like it's character merchandise. So how
Yes, sir.
you take character merchandise into the context of copyright and trademark laws, whether it is applicable for the metaverse or not?
So as of now, looking at the trend, very soon character merchandising will start on the metaverse as well. So as it is in the real world, when it comes to character merchandising, licensing and assignment are the two solutions which are used for character merchandising in a legal format. So in the metaverse too, we need to frame certain, we need certain legal frameworks with respect to authentic licensing. And when even when we are licensing in the metaverse with respect to character merchandising, we should get the KYC of the person getting the license for that, because it is inevitable to stop character merchandising on metaverse. It has almost started in, like, in Snapchat also. You can see that there are clothes available for your avatars which has certain characters and brands. So I think licensing, authentic licensing, is a good solution for that.
Okay, thank you, Palak. We will definitely look forward to your paper, and we will see if any changes is necessary or not. Yeah, thank you.
Thank you so much, sir.
Now we will move ahead with Advocate Siddharth, if it is fine with the
Yeah, am I
audio and
audible, sir?
visuals. Yeah,
Am
your
I
voice
audible?
is. Yeah, you are audible now. Yeah, you may go ahead.
Okay. Yeah. Okay. I'm Siddharth. Good afternoon, and thank you, Vin and CDPIR, for providing me this opportunity to present this small yet enticing paper and an important paper, Geographical Indications, Safeguarding Regional Products and Heritage. First and foremost, what are GI? GIs are labels that certify the origin and unique qualities of products tied to a specific region. For example, like somebody said, dazzling tea, Mysore silk. Even more recent would be Bengal's Rasagola, Odisha Rasagola. So these are legal recognition of products tied to a region's unique traits. Banarasi sarees. The major significance of this is preservation of cultural heritage, authenticity, and economic benefit. India, for that reason, Greece and many other countries also, they have rich culture. India specifically has got a rich cultural heritage, and this geographical indication normally protects this thing, this rich cultural heritage that we actually have. And now, this geographical indication of goods came in of 1999 came into effect in 2003, wherein a particular community, a particular designated area, can file for the protection of its cultural heritage. For example, this Konark store carving in Odisha. So that area mostly depends upon that stone carving for their livelihood. Or for that purpose, if you see the handicrafts that come from Pipli, Odisha, those are also those people, that area. If you go to that area, I've been to that area, I've seen that. Though that area is only covered with those architects like who designed this, who their sole livelihood lies on this. Then you have to make an application. Then there will be objections. Normal process which follows in a trademark. The same thing will follow in a geographical indication, and there are various certifications. Till today, would you believe, from 2003 to 2024, almost 21 years, we have only 361 geographical indications to date, which is quite low, but slowly it's increasing. On the contrary, 15 of these 361 registered GIs in India are from foreign countries, including Italy, France, UK, the USA, Ireland, Mexico, Thailand, Peru, and Portugal. So people are slowly recognizing the importance of importance of this particular geographical indication. How does it help? What is the importance? It helps in premium pricing of authentic products, supports rural economics and job creation, boosts exports and global recognition, preserves traditional skills and cultural heritage, which is very very important. Now let's take some small case studies of India. I'll also give you one case study of champagne, which is a foreign case study. The Darjeeling tea. The Darjeeling tea, it's known as champagne of teas, and this case was basically against ITC, who started Darjeeling, who adopted the mark Darjeeling for its services sector, and even argued in the court that since the goods are different, there will be likelihood of no confusion. But the court held against ITC's defense and said no, Darjeeling tea is the champagne of teas, and that means and granted an injunction to prevent the misuse of the name Darjeeling, as it could harm the region's tea industry. Then let's come to this Bengal Rasagola. Now this was the West Bengal claimed that it was the creator of Rasagolas, while Odisha came out with a very strong defense. I was a part of this case also, though I'll not speak in favor of West Bengal or Odisha, but I'll just give you the importance, like how GI protects, what GI protects. So they claimed, Odisha claimed that since Lord Jagannath, since this before even Rasagola was ever introduced to Bengal, Lord Jagannath used to offer Rasagola to Lord Goddess Lakshmi, so that he could enter the temple after he comes back from his mosses, from his aunt's place. So that way, after this defense, what happened was Bengal Rasagola got a GI protection, as well as Odisha Rasagola also got a GI protection, catering to the quality of the sweets which were manufactured and traded in both the regions. Then we have Mysore silk. It's a prestigious variety produced in Karnataka, primarily in Mysore. Karnataka, you have Bengaluru, but primarily in Mysore, this preserves the traditional weaving and ensures quality. Banarasi sarees safeguards artisan livelihoods and global awareness. Now, if we talk of the Bikaner case also, the Bikaner Wala versus New Bikaner Wala, the defendant used a name similar to the plaintiff's well-known brand Bikaner Wala by naming its shop as Agarwal Bikaner Wala. The court held that using a similar deceptive name for selling the product was an infringement of the plaintiff's rights and could confuse customers. So the defendant was ultimately refrained. In Comité Interprofessional DU Win de Champagne versus Chinar Agro Food Products, the use of the word champagne by the defendant for a non-alcoholic sparkling drink was restrained. The court invoked Section 22 of the GI Act while injuncting this particular defendant, Chinar Agro Fruit Products, in 2011. Champagne was registered by the plaintiff as under the GI Act. The defendant's use of the word was deemed an infringement as it violated the plaintiff's rights under the GI law. Now, before I go to the challenges, the GI law normally falls within the purview of the various laws and treaties that we have, that is TRIPS and also WTO. So the Madrid Agreement provides for the internal registration of marks, suggesting a mechanism for protecting GIs across member countries. If you see the Lisbon Agreement focuses on the preservation and global registration of appellation origin, further enhancing the legal framework for GIs. The WTO plays a vital role in protecting GIs through TRIPS agreement. The agreement sets out global standards, particularly if you see Articles 22 to 24 of Part 2, Section 3 of the TRIPS. They outline these requirements which all WTO members countries must follow. In these lines, the GI Act of 1999 was adopted by India. Now, if you see the product, so under the Indian law, a geographical indication is a mark that identifies a product as originating from a specific region, territory, or locality. The product's unique quality, reputation, or other characteristics must must be closely tied to its geographical origin, which you have to show during your application at the GI registry, which is currently in Chennai. For manufactured good, at least one production process such as processing or preparation must occur in the identified region. Registering a GI in
Mr.
India since the
Siddharth,
yeah,
Mr. Siddharth, please move ahead to the protection of cultural heritage via GI.
yeah,
We
yeah,
are
yeah.
eager to listen that. Yeah, that
Yeah,
portion.
so it will just two minutes. The challenges in protecting GIs will limited understanding among rural producers, quality control, variability in standards, destroys consumer trust, counterfeiting issues of GI labels domestically and internationally, challenges that we have. These are some of the recommendations. Just one second. Okay. Uh, what are these the cultural how to protect see it the cultural heritage normally gives see the broader impact of GIs that happens will be the market access, premium pricing, and growth in exports. The cultural heritage protects regional identities and traditional crafts, which are prevalent in India, which are much prevalent in India. And it the social aspect of it encourages community pride and sustains artisan livelihoods. So that is how the cultural heritage is protected. So it bridges gap between tradition and commerce, critical for preserving heritage while driving economic growth. Then the need for robust policies, awareness, and global integration. And call to action from my end would be strengthen the GI ecosystem to unlock its full potential. That's it from my end. Thank you.
Okay, Mr. Siddharth, question towards your presentation would be, what is your take on the unfair use of geographical indication registration? We also saw when we did on a ground, like there are people, there are registered society who are taking up the GIs, but later on they are not the real proprietor, or they are not the real users or the makers of the GI products. In such cases, how the government should take initiatives, or how
Sir,
the framework.
as I slowed, I'll just keep that one. There should be awareness campaigns in regional languages. That is foremost important because this traditional these people do not know like what exactly a GI is, how they can protect their cultural heritage. So there should be ample awareness campaign. And there should be quality control through local certification centers. The government local certification centers to ensure quality control. Then should be anti-counterfeiting measures using blockchain and stricter enforcement policies. The government should include stricter enforcement policies. So these things the government should do so as to protect people, the originality of the GI from those who are copying.
Okay, thank you, Mr. Siddharth, for your presentation. We will look forward to your paper.
Yeah,
Thank
I'll
you.
wait for. I'll wait for. Thank you.
Now we call Miss Suman Jain for presenting.
I'm presenting my.
Yes, Miss Jain, you can present your paper.
Yes, sir. I'm connecting my presentation. Um, can you?
We got her disconnected. We may move ahead with Miss Pooja Shukla and her team. Miss Pooja,
Yes.
Miss Pooja, you are not audible.
I Can you hear me now? Is it better?
Yeah, you are audible now. Yeah,
Okay, thank you.
Please present your paper.
I Is my slide visible?
No, it's not visible yet.
Okay, it is just showing as buffering. Okay, can I start with the introduction?
Yeah. Yeah, Miss Pooja, you may start. It's
Okay.
showing.
Okay, so just a brief introduction. My name is Pooja Shukla. I am from Hong Kong Metropolitan University. And the title of my presentation is The Ghost in the Machine, Navigating AI Intellectual Property Rights in Hong Kong and Beyond. So basically, as we all know that with the introduction of AI, how it has changed our society and how it is producing new types of legal challenges given the creative processes, which include art, music, literature, and any type of design. And the existing copyright laws, which I'm going to call traditional, do not actually adequately cover the AI-generated content. So as of now, there's a big missing link between the legal clarity and the protection that is given to that the creators deserve to ensure fair use. So the biggest question is authorship dead? Because we are dealing with human creators while now we have AI generated work. So as we know that AI lacks consciousness and intention. So the question to contemplate is, can AI be considered as author if we use the traditional sense of copyright? So if AI is generating all the content, who actually is the owner of the content? Is it the developer? Is it the user whose data is provided? Or is it the entity which is actually owning the AI system? So there is a need to reevaluate the copyright principles to accommodate this type of new factor of non-human creator. So all of this also leads to ethical considerations. As we all know that any type of algorithm will definitely come with a lot of bias. Just like human mind, we all have biases. Similarly, when our human mind is collecting data, processing data, inputting that data, definitely there will be some type of bias in that output of data of that data set. So there is a high chance of having discriminatory outputs. It could be coming from any type of demographies, race, or people of color, or any other type. And so we are living in the era of Google, Siri, and Alexa, and all of them might have their own opinions of probably of the same question because they are working on different data sets. So there is a need to ensure fair usage. And needless to say that all these organizations which are involved in all these activities of AI or collection of data, they need to make sure that they are following the basic principles of ethics, fairness, transparency, and accountability, because data can be labeled the way you want to be. The data can be selected the way you want it to be selected. So the algorithm design that the organizations are doing, that must match with the mission of the organization. So there is, of course, a lot of gaps that we have in the existing laws. So first of all, we need to identify these gaps as to which are the areas where they are actually falling short. There has to be a proper clarity given. As of now, there is no clarity whether the AI generated content belongs to whom and how it is going to be viewed as, whether it is going to be human, non-human, or there's a possibility of even considering it to be hybrid. So we need to identify how we are going to label liability for this type of copyright infringement of AI content. And since it is non-human generated, so of course there's always going to be a discussion on how we are going to fix liability, how we are going to penalize, who is going to be the person behind AI who is going to take the blame for infringement. Then we have human versus non-human authorship and all the implications that we are going to deal with, because we are dealing with an entity which is not even human. So there are various case studies, as probably I believe everyone knows these days, the next Rembrandt or the OpenAI or the Google's Deep Dream, which produces images which probably I don't think a normal human being probably could make. So these type of case studies, they while they are very fascinating to look at, from the perspective of law, they bring out a very big challenge, a big question mark as to have we adjusted our legal framework according to this new technology. So because we need to make sure that there is a proper balance made between the innovation of the potential use of AI and also the protection of rights of all the creators. Then we also have, so in Hong Kong, we have copyright ordinance. So as such, all types of designs, all of these things are covered. And so far, the work is original. It does not need any registration. So the proof of copyright can be established through affidavit or any type of statutory declarations, and of course, only in the case of if there is any type of dispute. So far, it is original and it can be recorded in a material form. It can be covered under copyright law in Hong Kong. So the latest development in Hong Kong has been Hong Kong continuously strives itself to match with the international jurisdictions as to whatever the international standards the other countries have been following. So following that, there was a public consultation paper issued around 6 months ago, where the government is very kind of eager to find out what the general public thinks. So they have invited opinions and suggestions from the general public. So the basic aim is to maintain the equilibrium between AI development and the intellectual property right protection. So this type of comparison that we have been using in Hong Kong is kind of, I would say, if I compare that with different standards internationally that exist, starting from EU's copyright directive, which, as we know, is kind of a bit more welcoming. It is giving much more flexibility and is, I would say, open-minded. Then we have US copyright law, which is using the traditional approach of just,
Ms. Pooja, Ms.
yes.
Pooja, move ahead with your issues and also the solutions and recommendations.
So, in terms of recommendations, what we are suggesting is that we have to properly delineate the authorship, ownership, and hybrid work, and how this kind of intertwines, and how the legal thread is going to incorporate into the definitions of what is going to be which side it is going to fall on. Then we need to devise basic distinct rules and regulations on AI. We need to make sure that all of this development that we have been doing is in the ethics, is following the basic principles of ethics. It is strengthening the transparency and accountability of the organizations that you are using AI. And it needs to basically uphold the collaboration amongst various jurisdictions, so that because all jurisdictions might have different perspectives or different definitions of how the authorship and ownership. So it is very important that throughout, it is kind of streamlined in order to make sure that we actually effectively address the issue of ownership in AI. And to conclude, as we discuss the different approaches that are there in AI that work internationally, so we need some degree of harmonization to align with the rate at which, or the volume at which, the AI work is generated. We need to make sure that the systems that we are using is coherent, transparent, and fair, because we need to strike a balance between what AI has a potential, what it is capable of, and also striking a balance to protect the rights and fair usage of AI. Thank you very
Okay.
much.
Thank you, Miss Pooja. Miss Pooja, like one question to you would be, in India, what we see when we talk about the copyrightability of a content generated by AI, it's like the copyright is provided to a human author. Like the content of human element is necessary, because when we look into the definition of person, like they are only natural person is eligible to get a copyright. So upon that, what is your perspective on the Hong Kong's law that a copyrightability of AI is possible or not, because in our future time, when majority of the works would be done by the AI, where not even a portion of human engagement would be present, at that point of time, what would be the uses and what would be the licensing right over the copyright over those area? Yes.
Okay. Well, as of now, as we speak, the existing copyright ordinance already under Section 113, it already has a category where it recognizes computer generated work. It already does that. And in that category, it says, of course, the ownership goes to people who have been associated with creating that computer generated work. So these are the people behind the AI work. So this has been, so I would say Hong Kong has been kind of at par with the international standards. And of course, this consultation paper that has been issued now is going to further segregate whether it is possible to separate the machine, the non-human factor, with the human behind that machine. So I think that is yet to be seen. So as of now, as we speak, Hong Kong does recognize computer-generated work.
Okay. Thank you, Miss Pooja. We will look forward to your paper.
Thank you very much. Thank you for your time and the invitation.
Thank you. Thank you. Now we call upon Miss Uma Narayanan and Mr. Ajit. Arya Anil, Mr. Arya Anil, for presenting the paper. Yes, Miss Uma and Arya Anil.
Good. Good afternoon, sir.
Yeah.
So just a second, I just.
Please present.
Yes, sir. I just connected the presentation, sir. It's just loading. So is it visible?
Yeah, it's visible.
Okay. So the topic for today's presentation is rooted in tradition: how geographical indications protects regional heritage and empowers communities. My previous colleagues who have presented, previous presenters who have presented, have already discussed in detail as to what is GI. But I just would like to give you a small introduction as to intellectual property rights protect the creative and inventive outputs of human mind, granting originators legal recognition and
Miss Uma,
exclusive
directly
economic benefits.
Miss Uma, directly move ahead with your objectives of the paper and the solutions and suggestions and also problems. Yeah.
So, sir, I would move forward to the fifth slide of my presentation, which mainly talks about what is market differentiation that we get through geographical indications. So, when a producer, a small scale producer or a woman producer, when they try to produce goods and when they can differentiate the original between the counterfeit goods, then that is called as brand recognition. Now, price premium is the small scale producers face a issue when counterfeited goods are already available in the local market. So, to distinguish that, they should be given price premiums because they put in the original artwork, follow the tradition to create that particular product. So that is what we are mainly aiming at with regards to economic benefits for the local producers. Then coming towards community development, through this economic growth and advantages that we are providing to them, the community is formulated, and many people are actually, they are motivated to get included into this agricultural product formations and other GI product formations. Over the years, what we see is that even though we have GI to various products in various cities or towns or states, what is happening is that the number of producers are reducing because of the reason that counterfeit goods are produced in the market and they are not able to sell the original goods. So this is causing a lot of issues to the actual local producers who actually know the rooted tradition on the production market. Now, when we are talking about cultural and narratives of the heritage, any person who's producing this counterfeit products are definitely not knowing the traditional value or how the taste or how the smell or how the texture of the original product should be. That is only known to the particular people in the local community. So by linking these products to the specific geographical origin, it not only catches a market value or a value to the particular geographical area, but it also captures the essence of a community, the cultural identity, and how the consumers can connect with these stories. So, like for example, if you're talking about the Kashmiri Kawa tea or something of that sort, we can buy this over Amazon or any other websites for the resale. But how to have it traditionally, how to smell it, then taste it, that's what the community actually teaches us, which we should be promoting more for. Then the connection to the cultural heritage fosters a sense of pride and belonging amongst the local producers, strengthening their collective identity. It creates a deeper sense of appreciation for them with regards to the cultural richness of their region, both within the community and aspect as well as according to the world aspect. Now, coming to how GIs can contribute to the sustainability, we have done a case study with regards to Chanapatna toys. Now, Chanapatna toys was during the period of Tipu Sultan during the 18th century itself. So, during that period of time, these toys were made with non-toxic materials and it was very bright in color. They only use natural dyes. So this was the reason or attraction of Chanapatna toys that we were talking about. Now, when we're talking about this, we even get the counterfeit goods of Chanapatna toys in the market. But the quality and the standard that the Chanapatna original Chanapatna toys maintain is very, very different. So this is why the sustainability to the environment is also important because when we are using one of the remarkable aspects of Chanapatna toys is that it has adherence to environmental sustainable practices. The toys are traditionally made from locally sourced ivory wood, a fast growing and sustainable species, and this also ensures that the raw material used does not deplete the biodiversity, the region's biodiversity. So it's not only hurting, it is not causing any harm to the environment. At the same time, it is also bringing in the things that is actually attractive to the market. So this is how we maintain a balance. In addition to the sustainable sourcing, the artisans use natural and non-toxic dyes that is derived from plants and seeds such as kumkum, haldi, indigo, etc., which are used and which are safe for the children to pay. And also it's environment friendly. So again, the question of where to, where do we recycle this or how do we recycle this is actually avoided in this particular scenario. Now, coming to the challenges that is faced by the artisan, one of the significant issues is that lack of awareness amongst the consumers about the GIs and their implication. Many buyers, especially in the urban or city life or international markets, fail to distinguish between the original authentic GI products and the counterfeit products that is available in the market. So these are the major things that we would like to discuss. Along with this one last point that I would like to add is while traditional methods are integral to the authenticity of Chanapatna toys, integrating modern techniques could help improve efficiency and quality without compromising on the heritage value. Now, the suggestions that we would like to make here is with regards to this particular topic is that, sir, simplification of the registration process, basically making the small scale producers or the women or the artisans know about how to register and how easily this can be streamlined, and the bureaucratic process or the legal process can be streamlined to a much simpler method, and making these communities or the producers aware of this process is what the first step of recommendation would be. Second step of recommendation is strengthening the enforcement mechanism, that is enhance the cooperation between the local authorities and the governmental international bodies or government bodies in order to improve the detection, monitoring, and punishment for violation of GIs. So, if any counterfeit products are available in the market, that should be banned so that this particular artisans are protected for the value and the efforts that they put in to actually generate the natural products. Then, coming with regards to the capacity building for marginalized communities, empower marginalized groups, especially women and small scale producers, with regards to the resources and the support that they can get if they engage in a GI system, and implement more capacity and training programs for them, and which include sustainable practices, help them making the sustainable practices, develop sustainable practices, marketing, help them with marketing strategies, because all the small artisans would not be always educated with regards to all of this. So it is important that we give them a marketplace also, and also the best market practice, so that we can promote such things. Now, the last thing that I would like to say is incorporating environmental sustainability into GI practices is very much important, because to ensure that GI producers are producing this from the environmental goods, and goods that are hazard safety. So ensure that GI producers adopt environmental sustainable practices mandatorily, which aligns with our global sustainability goals. And governments and NGOs can create incentive structures that encourage the GI producers to adopt organic farming, sustainable resource management, biodiversity conservation practices, etc. So there can be a credit given to them in that aspect as well.
Yeah. Thank you, Miss Suma. One question towards your presentation would be: what is your take into the framework, present framework, and its applicability on the GI ecosystem? Like, since you talked about the biodiversity and the green technology regarding the GI, what's your take on it? Like, how government should come up with the initiatives to promote conservations, environment, and all this? Yeah.
So, sir, basically, what I have understood here is that the producers, the local artisans, are not aware of the procedure to register, basically. Secondly, they are not much aware of the sustainable development goals that we have. Basically, they know that we are in line with the environmental goals or whatever, but they're definitely not, aware of the SDG goals or something. So, basically, a training and awareness with regards to the same. Then there is over commercialization and over exploitation of the same. So basically, a big businessman would just come to them, approach them, and take the goods in large and sell it according to his wishes. So the direct hand or direct marketplace procedures is not happening. So that is one more thing that we are facing. And the economic success of GI products can drive intensification of the production, resulting in depletion of natural resources or soil erosion, etc.
Okay. Also, one question for you. Like, we recently saw one of the most challenging part in geographical indication is to maintain the quality after registration. So many times when we often talk to the registrar society of the GI, they tell us that how it is difficult to them to maintain the quality on a regular basis when they are commercializing it in the market. So how or what are the frameworks the government should take up in maintaining the quality of the GI product?
So basically, sir, to maintain the quality of the GI products, what they first have to concentrate is on establishing clear and robust standards. That is, that for a particular region or a particular state, they can come up with. They would definitely know the products, so they can come up with standards and should outline the production process, the raw materials, the regional methods associated with that product. For example, the Kashmir Pashima GI requires specific qualities in terms of the fiber fineness and traditional weaving methods, which we need to be strictly enforced. And also, they can also talk about the third party certification and independent inspection to be done with regards to the same.
Okay, thank you, Miss Uma and
Thank you, sir, for
Mr.
the
Anil
opportunity.
for this
Sir,
presentation. Yeah.
it's Miss Arya Anil. It's Miss Arya Anil, sir.
Okay, okay, it's Miss. Okay, Miss Aryan.
Thank you, sir.
Okay, thank you. Now I call upon Miss Suman Jain for the presentation. Miss Suman, yes, please present.
Yeah. Yes, sir. Okay. So, my topic for today is culture, how we can protect a cultural heritage, safeguarding cultural heritage with the help of intellectual property. While talking about the metaverse AI generation, do need to take care of our history, which is the sole product of South Asian countries. So, with regarding this, I saw the challenges which are facing by the South Asian countries
Miss Suman,
related
your
to.
presentation is not visible.
Yes, sir. So I can't able to connect my presentation here.
Okay, you may go ahead with the virtual visual and just your oral presentation.
Okay, okay, sir. So, the challenges currently we are facing is, while I'm from India and I saw that our cultural heritage, that is yoga, which is intangible intellectual property to our nation. During this process of my research paper, I saw that our culture of doing yoga is since 500 AD. So when I saw the patent has been given to some US member of a citizen called Bikram, and he registered his type of yoga, Bikram yoga, in our international patent. It has been revoked the process because we have filed a case against it. But this all practices which have been done, which hinder our cultural heritage, and also also lead us to not protecting our heritage. So for this I have done some of the research and came up with the case studies with where we have fought the inter countries like our basmati rice has been fought between the Pakistan and India, and somehow we got the registered geographical indication for the basmati rice. And accordingly there are many of the artistic work which has been from India and which has been infringed by many of the other countries. So with that, how we need to bring up the new policies to protect our cultural heritage, and how South Asian countries come to the one platform, bring one policy to protect their cultural heritage. When I saw the list of geographical indication of 2024, the South Asian countries have very less number of registration compared to Germany, US, China. So how this policy of making the registration easy and making a platform of sui generis, which has been termed given by the WIPO, that is the World Intellectual Property Organization. They even giving a platform for intergovernment to come with the regulation that will help South Asian countries to register their intellectual property. So there are when I see the process of intellectual property and the geographical indication registration in my own country, it is very typical, and it is not being able to process very fast. So with that, if we make it very simplified process, it will help our country to register it very easy way. While listening to the many of the presentation, I have heard that the UP had came up with this one state one product registration. So how come we implement that policy in our GI Act 1999, and how we promote this all over the South Asian countries? And people with many when I visited many of the South Asian countries, I see people are with culture. There are temples, there are heritage. So with that, we can also protect our cultural heritage by coming up the policies of this one state one product registration. And I also want that I also suggest.
Your voice is not audible. Miss Suman, your voice is not audible. Yeah.
Now I am audible.
Yeah. Continue.
Yeah. So, one of my suggestion is to coming up with the one of the regulatory body to protect all the cultural heritage, and suggestion should be made. When we say there is a AI, there is a metaverse. There also should be a AI based VI platform where people can visit to different countries' heritage and explore different countries' geographical indication and experience their own heritage by protecting their regulation body and by protecting their intellectual property under the same body. Uh, the I also need to mention that how a WIPO can help to come up with this regulation in our intellectual property. The WIPO already gave the cross border regulations for this intellectual property registration. They have come up with the one of the thing is intergovernment intergovernment agreements that can be bilateral, that can be multilateral. So coming up with these agreements between the countries like Pakistan
Miss
and India.
Suman, just move ahead with the conclusion and state how the cultural harmony can be
Yes.
protected or can be safeguarded by the intellectual property rights.
Okay, sir. If we see the chart now of intellectual property 2024 of our South Asian countries are lacking because of lack of awareness. So creating a one conference which make every regulatory body of the country can come at a one.
You are again not audible. Yeah, please speak.
Hello,
Yeah,
hello.
yeah, move ahead with the conclusion.
Yes, sir. So my conclusion is how we are creating this conference of making every advocate or every regulatory body to coming to this presentation and presenting their paper on intellectual property. And this is how we can create a conference between the regulatory body of different intellectual property of the different countries and making people aware of how they can grow in this sector of geographical indication, how they can protect their cultural heritage, and we need to make them aware that different countries like Germany and US, how they are going with this sector, and how we all need to bring the policy and how we need to simplify the process of registering and making an agreement between all the South Asian countries, making it very simplified to promote culture among all.
Okay. Thank you, Miss Suman. One question to you would be how you think that India should enhance the registration of GI?
Sir, just like UP can be one of the examples which I am currently seeing, and also the Tamil Nadu state is also they had represented their cultural so beautifully. They they have been targeting to register one good products and like one state one policy. This is how this one policy should be implemented by India to protect their GI. And I think if India can make this strong, they can forward it to South Asian countries because India has been a headquarter for all South Asian countries, and they have been a motivation for other countries. So if we start here in India by promoting this GI, and even UP can promote how they implement it, come up with so many GI within the year. This can be a motivation to different states to come up with different registrations, and this is how we can protect. And also advocates like us can promote and can give and guide, to different, and how we can, and also this will help to other to how it should be implemented in come this should be implemented and how
All
it is
right.
important to our nation. Yes, sir.
All right, Miss Suman, thank you. We'll look forward to your paper, and we will definitely recommend you to write something upon the increasing number or how to increase the number of GI registration in India.
Thank you so much, sir.
Yeah.
Thank you for this
Mo-
opportunity.
yeah. Moving ahead with the next participant, we have Nidhi Sharma. Miss Nidhi Sharma, you can present your paper now. Miss Nidhi Sharma, Miss Nidhi Sharma, you are not audible and visible. Okay, we may move with the last participant, Abhinava Ghosh. Yes, Abhinava.
Afternoon.
Yeah, you're audible and visible.
Yes.
Before moving ahead with your presentation, we would like to have your formal written email because you are a literal entry. So you must write a
Yes,
formal
sir.
mail after this presentation. Yeah,
Yes, sir.
you may move ahead
Okay, sir.
with your.
Okay, sir. Okay. Sir, is my presentation is visible?
Yeah, it's visible. Yeah, go ahead.
Okay. So, very good afternoon. So today, I am going to discuss about the IPR paradox in biopharmaceutical innovation, addressing legal loopholes and ethical concerns. So, exploring the impact of intellectual property rights on the development and access to advanced biopharmaceutical therapies. So, in this, I, Abhinav Ghosh, on behalf of my co-author, Shubham Shakti, we would be presenting on the research, the IPR paradox, addressing legal loopholes. So, today, we are going to explore how IPR intersects with biopharmaceuticals, innovation, training, and advancements while presenting unique challenges. So, the IPR and biopharma addressing legal loopholes. So, there are some gaps in IPR frameworks. That is, biopharmaceutical industries faces significant gaps from the application of the Patents Act 1970. So, there are challenges of compulsory licensing and issues with biosimilars, and there is a need for harmonized global regulation. So moving to the next part, the prelude, the introduction of the biopharmaceutical landscape. So in the era of disruptive technologies,
Your
pharmaceutical
slides are not
companies.
moving. Your slides are not moving.
Sir, is it now moving?
No, it's not moving. Yeah, it's
So is
moving
it
now. It's moving.
okay. So okay. So the introduction to biopharmaceuticals in this era of disruptive technologies and pharmaceutical companies leverage high-end technologies for innovations in biopharmaceuticals. So there are therapeutic drugs manufactured for biological sources, including biologics and biosimilars and gene editing technologies. So there are some impact on healthcare. Biopharmaceuticals transform healthcare by offering innovative therapies for disease previously deemed incurable. So in India, the biopharmaceutical industry is known for producing high quality and affordable biosimilars, contributing significantly to the global market. So there is a data I have pointed out, that is today 90% of the prescriptions are filled with generics and biosimilars, indicating lack of monopoly in treating medical conditions, and IPR fosters innovation and competition, offering a wide range of choices and patients. So global access through generics. The United States provides a global access to a broad range of treatment through the use of generic medicines and biosimilars. So, genesis of biosimilars and biopharmaceutical in the innovation of IPR. So, the historical milestone in India's pharmaceutical history, that is began with the Bengal Chemicals, that is from 1901, followed by Hindustan Antibiotics Limited and in 1994, and the Indian Drugs and Pharmaceuticals Limited in 1961, making this journey towards self-sufficiency. Key innovations in biotechnology are significant innovations include the discovery of insulin in 1921 and the introduction of recombination DNA technology in the 1980s, paving the way for biologics. So transformation of traditional drugs to biologics, the journey of the transformation of the traditional drugs to biopharmaceutical sector has evolved from chemical-based drugs to biologics and biosimilars, addressing complex and disease more effectively. Previously, which are incurable diseases are now curable with the help of the biosimilars and biopharmaceutical innovations. So current statistics of the Indian pharmaceutical markets, India's pharmaceutical industry generates more than 38 billion annually and ranks third globally. So, I have the foundation of IPR in biopharma, key developments and challenge. So initially, the patent laws were created to protect mechanical devices, manufacturing processes, and chemical inventions, promoting public disclosure in exchange for exclusive rights. So later on, in the late 20th century, due to the advancement of technology and rapid advancements in biopharmaceutical sectors by different multinational agencies and multinational enterprises. So after, in 1970, the US came with their Patent Act, and in Patent Act relating to biopharmaceutical innovations. So after this implementation of the Patent Act in 1970, so there was a significant case, that is Diamond versus Chakraborty, that is held in the US Supreme Court. So in this court, the US Supreme Court identified and upheld that patent on genetically modified bacterium, setting a precedent for patenting in live organisms. So after 1980s, so after when in 1970s, the US implemented its Patent Act relating to biopharmaceutical innovations, India was very far behind that. So in 1970, India was only able to include its own Patent Act, and it only focuses on, instead of process, it's aiming to ensure affordable access to medicines. So as per the TRIPS, the trade related aspects of intellectual property rights, TRIPS agreement, India amended its Patent Act thrice, in the year 1999, in the year 2002, and in the year 2005. So biosimilars and biosimilar, a part of biopharma, that is we can simplify this in very simple words, that is biosimilar are identical to existing biological drugs, emerge as a cost effective solution post patent expiration. They ensure broader access to complex disease treatments. Market dynamics in Indian pharmaceutical industry is that with an 8 to 9% annual growth rate, and it valued over 22 billion in 2013, and it is approximately going to be more than 35 billion in the year 2020-25. So there is a cost effectiveness and accessibility of biosimilars, because it is a medicine slightly different from the original compound of biologic drugs, and it can maintain therapeutic efficacy and improving accessibility, especially for economically disadvantaged populations. So impact on global healthcare and affordability, biosimilars have played a very crucial role in impacting global challenges, like some of the drugs costlier than more than 2 to 3 lakhs, that it can be reduced to 10,000 per month. So there are some regulatory challenges in biosimilars. So there is lack of transparency in Indian's framework. So India's biosimilar approval process is less transparent and stringent compared
Abhinava,
to
just move, Abhinava, move ahead with move ahead with the problems which we are facing in the healthcare segment, and also what are the solutions we should take into consideration in IPR.
Okay. So, as we have our Competition Act 2002, and we also initiated through various landmark cases, we have so challenges in patent regulation and GMO. So we have various landmark cases that prove we have developed our law, and those things are that in the case of Roche versus Cipla 2008, the main issue was patent infringement. So in this case, the court found out that there is no infringement of order to pay the damages. In the case of Novartis AG versus Union of India, the patent application of a drug that ruled that enhanced therapeutic efficacy was proven, rejecting the Novartis application. So the main problem that we are facing is that in the United States, there is United States BPCIA. We call it BPCIA, and it is regulated for only for biosimilars and biological drugs. But India, we do not have any certain provisions relating to biosimilars. We only have Section 3B of the Indian Patent Acts, which only prohibits invention against moral principles, and it just give us some guidelines that what are the things that we cannot patent. So in India, we need the compulsory licensing as per the Competition Act 2002, that must be followed. And the proposal for legal reforms and policy interventions are impact of unpredictable timeline in IPR cases. So there is a lack of clear, consistent timelines in IPR cases. Disposing patent application lacks mandatory timelines and stockpile clarity. Stockpile is crucial for timely generic launches. Post patent expiry is not addressed in Indian law, allowing stockpiling and 6 months before patent expiry. Thank you, sir.
Okay, so Abhinav, tell me how the patent protection in the healthcare segment can be more towards giving benefit toward to the people. Means how the government can make it in a way that it also, along with providing the positive monopoly, it also benefits the people at large. How you think in a healthcare segment the government should take initiative?
Okay. So, as I have stated that there are three landmark cases, the Supreme Court of the country, like in the case of Novartis AG, in the case of just a second, sir. In the case of Bayer Corporation versus Natco Pharma, so they have made a drug that is cost up to they have made a drug for treatment of cancers that is cost up to 3 lakhs per month. But Indian companies have created through biosimilars and biopharmaceutical innovations, they have manufacturing the drugs in India, and they are they are able to treat at the cost of 8,800 per month. So compulsory licensing and must be provided with by focusing on the utilitarian theory of Jeremy Bentham, that is maximum happiness for the maximum number of people.
Okay.
That's
So according to your take, compulsory licensing should be focused upon when there is a failure of patent.
yes, sir.
Okay.
Yes. Okay.
All right. Thank you. We will move ahead with the
Thank
next participant.
Thank you so
Uh,
much, sir, for considering me. Actually, I am leaving today. That's why I have requested the host and I have joined, and I will mail right now. Okay, sir. Thank you very much, sir.
okay. Thank you. We will also look forward to your paper. Okay.
Yes, thank you so much, sir.
We will move ahead to the next participant, Miss Nidhi Sharma. Miss Nidhi Sharma. Okay. Miss Nidhi Sharma is not responding. We'll move ahead to Anushka Srivastava. Miss Anushka,
Yes, sir.
yeah, please present your paper.
Hello, good afternoon, sir. Am I audible?
Yeah, you are audible. Please present your paper. Yeah.
Sure, sir. Is my screen visible, sir?
Yeah, it's visible.
Okay, thank you so much. So, good afternoon, everyone. My name is Anushka Srivastava, and today I'll be presenting my paper, which is on the topic AI generated works, ownership, and legal protection. So first of all, let me introduce you to my topic. As we know that AI has revolutionized creativity, producing works in music, art, literature, and software that rival human innovation. The traditional notions of authorship are challenged as questions arise about recognizing AI developers or users as authors. The existing AI IP laws requiring human creativity struggle to address entirely AI generated works, creating legal and philosophical uncertainties. So basically, the paper that I have written on this topic is about that. As we know, the intellectual property laws are there to protect the rights of human creativity, of human intellect, that the creative works which are created by the human intellect. Now, what happens when the intellect has turned into artificial? How can we protect those rights, and what about the works that are created by the artificial intelligence? So first of all, we'll see. I've studied what is the need for legal protection of AI generated works. First of all, there needs to be a legal clarity about ownership and attribution. It is essential to determine who owns the rights of the AI generated works, whether it's the developer, user, or the entity deploying the AI system. This ensures fair attribution and prevents disputes. Secondly, there are economic incentives. It is very important to protect AI generated works because it will encourage investment in AI technology by ensuring creators and innovators can commercially benefit from it. Thirdly, it will also encourage innovation, the legal protection which will be there for the AI generated works. It will foster a supportive environment for the development of creative and innovative AI solutions driving technological progress. As we know that AI will continue to work in this environment, it will continue to grow. It's a technological development that will happen. So it is important to support that environment, to support all those things, the technological developments, by providing a legal protection so that there's no misuse and it ensures fair competition. Establishing guidelines for the use and protection of AI generated works, it will help in addressing ethical concerns, such as ensuring fair competition and preventing misuse. Also, there has to be global consistency. With AI's cross border application, consistent legal frameworks ensure that AI generated works receive uniform recognition and protection across jurisdiction, reducing uncertainty for creators and
Miss
businesses.
Anushka, Miss Anushka,
Yes, sir.
move ahead with the legal frameworks and its challenges in the AI
Yes,
generated
sir.
law.
That's the next thing. So, what is the existing legal framework? First of all, we'll see that what is the legal framework that we have currently in India. So in India, we have IP laws such as Copyright and Patents Act. The creative works generated by AI mainly focus on the creative works such as music, art, literature, which will be covered under the Copyright Act, and the software or such things which will be covered under the Patents Act. So we have these acts to provide protect such things, but they are designed to protect human creativity and innovation. These laws actually lack provisions to address the unique challenges posed by the AI generated content. So the issues like authorship, ownership, and protection of AI-driven works remains unresolved in the Indian framework. As it has been seen in various case laws, such as the Eastern Book Company versus DB Modak, the Indian Performing Rights Society versus Sanjay Dalia, the courts have, a lot of times the courts have said that the copyright applies only to the original works created by human minds, and it requires human involvement to protect them for intellectual property rights. If the human involvement is not there, it cannot be protected under the intellectual property laws as per the existing legal framework. It has also been seen in other case laws, which also says that originality must stem from human creativity. So it highlights the gap in copyright protection for AI generated works. Such is also the case for patents, where also it requires human novelty. Now, when we see the global perspective, what are the other jurisdictions are doing for these things? Again, all the other jurisdictions that I have studied, which includes the US, European Union, UK, Australia, all these laws or jurisdiction, they say that the copyright and patent recognition can only be provided for human creators, and that is only which is eligible. So the AI is not yet included in any of the jurisdiction or the frameworks to include it as a author to give protection. Now, if we see what are the challenges, first of all, there is the challenge of authorship and inventorship challenges. Like who should be the author, who is the inventor? The legal frameworks do not allow AI to be the author or the inventor of any creative work. Also, there's absence of legal frameworks for AI's role. As AI is a very new and emerging thing, the legal frameworks have not yet included those things in their framework. Also the ownership and control, who will be owning the AI generated works, who will be in control of that. There are a lot of ethical and moral dilemmas, like if someone has created something with the help of AI, so will the moral rights of that developer be protected or not? And also there are global discrepancies in IP laws, whereas various IP laws in different jurisdiction, they cover different things, like some things are protected in this country, some things are
Go to
not.
your challenges, Anushka. Go to your challenges, solution for the
Challenges, sir,
challenges.
with challenges, I
Solution.
mean that what are the challenges in protecting the AI generated work for giving legal protection? So for legal protection, it is difficult to define authorship and inventorship. There's absence of legal framework for AI's role. These things, that is what I mean by challenges.
Okay, and what are the solutions you are providing in your paper?
Yes, sir. So I've provided a few of the recommendations which might help. First of all, I suggest that there should be a new category of IP for AI generated works. Basically, I don't suggest that there should be a new act or new law apps altogether for AI generated works, but the existing copyright patent laws which are already there, they should create a new category of AI to include such kind of works and such kind of creative activities that are happening. Also, it should clarify what are the ownership and what is the rights. Matlab, who will be classified as the owner, who will not be classified as the owner. So, first of all, I also suggest that one of the points is recognize AI as a tool, not as an independent creator. I believe that with my study, I've come to this conclusion that it is not feasible to make them a legal person to provide all the rights to the AI itself. Rather, it would be better if we recognize AI as a tool because AI is not generating everything absolutely on their own. We give them prompts, the human creativity is there. The humans have to give them prompts, they have to make them do the work which they want. So the AI should be recognized as a tool with which you are creating things. So it should be clarified like if you're creating something with the help of AI is the tool, and who exactly is the original owner of that work, the author of that work. And obviously, we should encourage research and development on AI and IP because these are the emerging fields, and that will continuously help in knowing that what is better and what are the new upcoming challenges for these things. And obviously, there should be we should establish clear ethical guidelines to protect the misuse and any kind of disputes. And international collaboration should be there to harmonize the IP laws that are already there.
Okay. Okay,
Yes, sir.
thank
So,
you, Miss. Yeah, thank you, Miss Anushka. Only
okay.
one question from my side for your paper would be
Yes, sir.
what you think the present intellectual property law, which only deals with the uh, applicability over the human subject or having any human element, then only the copyright is provided.
Yes,
What
sir.
is your take upon the copyrightability when the subject matters comes for a AI generated content or any artistic work which is developed by AI? Let's say there are
Mhm.
the companies who are holding artistic work which are holding copyright over the artistic work developed by the platforms like ChatGPT or any other platforms. What would be the stand upon the Indian law if a challenges arise to those companies who are holding the copyright over those?
Okay, sir. I believe the copyright protection should be given to the person who is giving the prompts of creating any work. Like if I have given the prompts to ChatGPT to make such an art piece or make such a music, so the copyright protection should be given to me while recognizing AI as the tool that I have used AI and these are the things that I have used.
Okay. All right. Thank you, Ms. Anushka. We'll be looking forward to your paper.
Okay,
Thank you.
thank you so much, sir. Thank you for the opportunity.
Now I call upon Miss Nidhi Sharma for the paper presentation. Yes, Miss Nidhi.
Uh, Thank you, sir. Please give me a minute so that I can share my slides also.
Yeah, definitely, definitely.
Sir, is
Your voice is scattering, Miss Nidhi.
sir, is my PPT visible to you?
It's not visible. Please.
Present. Just a minute, sir. Just a minute, sir.
Okay. Miss Nidhi, do fast.
Yes, sir. Sir, is it now visible? Because I think I'm having some trouble in my net.
If you're not able to present, then you can go with the oral presentation.
Okay. Okay, sir.
Go
Okay,
ahead
sir.
with
Sir,
the
that is fine, sir.
okay. Go
Okay,
ahead with the
sir.
oral. Your voice is not audible, madam. Go with the oral presentation.
is it audible now?
Yeah, it's audible. Yeah, go ahead.
Okay, sir. Okay, sir. Sir, am I audible now?
Yes, yes, yes. Go ahead with your
Okay.
presentation, madam. Again, you are not audible, Miss Nidhi. You are not audible. You are having some network issue.
Hello.
You are having some network issue. If you are facing network issue, you may turn off your camera and speak.
Okay, sir. Sir,
Yeah,
am I
go ahead.
audible now?
Yes, yes, it's audible. Go ahead.
Okay, sir. So,
Madam, your voice is stopping again and again. It's not audible. Miss Nidhi, it's not audible.
hello, sir, am I audible now?
Yeah, you are audible. But again,
Sir,
it's
can
just.
you, sir, can I join in another 10 minutes next to what whoever gives the presentation? I'll join from my mobile.
Your presentation is the last presentation, madam. We'll be wrapping up with
Sir,
the
please,
session.
if you, okay, sir. Sir, please, if you can just give me 2 minutes, sir.
Yeah, definitely,
Sir,
definitely. Take 2 minutes and join first. Yeah.
sir, am I audible? Sir, am I audible?
Yes, you are audible now. Yeah.
So, as we all know that artificial intelligence has a significant.
Again, your voice is not audible.
Sir, am I audible now, sir?
Yes, you are audible now.
Sir, am I audible?
Yes, you are audible.
Yes, sir. So, I will just give a brief concept of copyright first.
Madam, I feel your network is not right. Your presentation is scattering in between. Your voice is hardly audible.
Uh,
Please be first. We will not wait more than 2 minutes. Join in 2 minutes.
okay, sir. Okay, sir. Okay, sir. Okay, sir. Sir, am I audible now? Sir, am I audible now?
Yes, you are audible. Start.
Okay. So, this will be a brief clarity about how the artificial intelligence has played a significant role also, but in another way, it has led to very, drastic challenges for the world of IPR. And when we talk about with respect to different countries of the world, it will be it plays a very crucial role. So it has several exceptions, and common creativity is one of them. It's a collection of license that provides the creator the authority to determine what uses the restriction. Now, the only international convention which talks about the instruments which talks about the copyright is Berne Convention and WIPO Copyright Treaty. But none of them, as we see right now, none of them, except for the domestic laws made by different countries, have actually made provisions related to artificial intelligence. Now, if we talk about the international scenario, there is no concept of non-human authorship. So, for a copyright to get protection, you have to be a person. Now, this word person has been defined in various laws, and he has to be a natural person. So the debate around the world is going with respect to artificial intelligence is that it's not a natural person. So when the source of information which has already entered into a intelligent machine, by and created by human itself, then how it raises a question that how can one grant the status of a natural person to an intelligent machine which has already been created by a human agency or human being. So here both the concept of artificial intelligence and the concept of copyright clashes, because to get a copyright protection you need to have you need to be a natural person first, and there has to be a what do you mean call it as creativity. When we when we talk about creativity, it's that creativity only comes from a natural person. Now what artificial intelligence what AI does, gathers all the data from the world and then it creates a new thing. That means that data which has been collected by AI to create a new work is already been entered by a new person. Suppose even if we say that the work created by an AI or a machine or an intelligent machine so called, that work should be protected, and recently a few countries have also given the protection, granted patents to an AI created work, generated work. But if we see in other perspective, aren't we vitiating the concept of licensing? Because the how do you give the work, how do you give the license for a creative work? That license is only given by a natural person and not a machine. Is that machine is capable of getting sued and being sued? So these concepts are nowhere defined and are big challenges which we can face in recent times. Though AI has played a crucial role because it is already saving time. Because when there's no human intervention and you just have to put data into it, and it creates a new work. But our domestic legislations, even when we talk about the world, there are many countries whose domestic legislations are not sufficient enough to tackle the problems and challenges created by AI. Now, when we talk about Japan, the copyright of Japan declares that when there is a freedom of thought or concept or ideas which fit within the realm of literature, music, science, is covered by IPR. Now, the word creativity here emphasizes the authority personality. As a result, it can be deduced that only human work is given priority and not a machine language. That's what the laws of Japan says. Now, this is an international scenario. Another country I will discuss about is United States. Now, the United States, like Japan, does not acknowledge or defend the innovative work of robots or artificial intelligence. Though countries like India, I'll be dealing it with shortly when we discuss about Indian scenario as well. But when we talk about international scenario, the AI is creating a major role because it is less time consuming, and when you what do you call you need to put a lot of financial inputs into your R&D to create new work, so that they can get protection. But when we talk about AI, no such thing is it's not that big concern. So in on one hand, it is obviously very supportive in on one hand, but when we see the challenges raised by it, when we see the drawbacks of AI, it is posing a bigger challenge than its advantages. When we talk about United Kingdoms, the laws of UK go against the norms in several of the nations. Now, according to Section 9 of Copyright Designs and Patents Act, the author is considered to have made the necessary preparations for the creation of a literally music and artistic work when it is created by computer. So here, a major drawback, a major area of concern also comes to the place when we talk about the computer programs. Anything which is created by using the computer programs, will that be liable to get protection under the Copyright Act? So that's the major challenges. But the only thing what we can see, and whatever literature I have read and gathered to make this to make it understandable, is that though there are various countries who are granting protection to AI generated work, but still many challenges are there. Like one of the questions is what I just raised, that will it vitiate the concept of licensing? Will like international instruments who are not talking about or who are not defining the term persons or natural persons, whether those definitions have to be amended to bring in AI into the international realm of arena to get protection, and to so that we can get give protection to AI generated works?
Okay, Miss
All these
Nidhi.
are the bigger concerns, right?
Miss Nidhi, Move ahead with
Yes,
your
sir.
solutions. What are the solutions you have imposed for your paper?
Yes, sir. Yes, sir. Sir, so according to my understanding, what we can do is because their domestic legislation is not sufficient enough to tackle these problems, and in international instruments we do not have such provisions. So, as per my understanding, it's a better way that we should first review the international instruments and make provisions and those guidelines and principles which also talk about AI, and at least try to differentiate, at least try to deal with the challenge of a few questions like the natural person definition, because till the time this definition is there, AI will never come into picture, because to get protection you have to be a natural person. The creativity comes from a natural being, not from a machine generated, because that machine is already gathering data from where, which is already generated by a human being. There is no newness, there is no creativity. So that creativity thing is a bigger aspect. We need to go through those international instruments and make provisions and amend some definitions related to natural person, and we should incorporate few provisions dealing with AI, so that there will be a better understanding, and some kind of gray area which has been created by coming of AI and the legislations, domestic legislations of copyright, will not be clashing, and there will be a solution for these problems as well.
Okay. Thank you, Miss Nidhi. Thank you for your presentation. We
Thank you,
will
sir.
be definitely looking forward to your paper and to provide holistic suggestions if possible from the organizing team.
Thank you, sir. An opportunity for attending such a big conference, and we will definitely look forward for your suggestions.
Okay, yeah. Thank you so much. So coming to the last stage of our conference, like tomorrow and today, we are having the conference. Today we held the categories for the faculty members as well as researchers and professionals. So in order to come up with holistic solutions, holistic suggestions and recommendations. We have recommendations from various speakers, various lecturers coming forward and provide their suggestions in today's session. We saw. So, from my part, I congratulate all the participants who took part in today's discussion and gathered and shared knowledge on the intellectual property rights discussion. IPR, if we contribute, if we look into the ambit of IPR, it's not only about uh, just a intellectual property to be preserved. It's the heritage, it's associated with the culture, it's associated with the tradition. It's far beyond than the existing of mere intellectual property rights. So, coming to that notion, I come to the conclusion of this conference room today. And with this, I provide my heartiest thank to Professor Dr. K. Shamla for being in the session as a panelist, as a panel judge for adjudicating this session. And we look forward to the participants tomorrow for the day two of the intellectual property conference. We'll be hosting the students from all across South Asia for presenting their paper tomorrow, and we look forward to the same support and same celebration of the intellectual property rights across South Asia. Thank you all of you. Thank you.